Wait, see everyone being on time. That could have done the same. We've got two things we're taking care of this afternoon. We have a bond hearing. Are you going to be handling that, Mr. Pinion? Mr. He's nearby?
Yes.
Okay.
Just seated there.
We're going to do that first. Mr. Bowles, if you're ready, we'll get Mr. Jackson out here in a second. We're up on YouTube. Ms. Nelson, can you hear me?
Yes, sir.
Great. So we're going to do the bond hearing first, and then we'll turn to Mr. Goolsby's case. Are you here, sir, for the Goolsby matter?
Yes.
You think so? Yes. Good. All right. So you've got the officer or officers you need? Okay. Then are you ready for Mr. Jackson?
I am, Judge.
We could bring him out. We'll get Mr. Abate here, but that way you and Mr. Did you go back to chat with him, or have you not seen him today?
Not today, no, I saw him a couple of days ago.
Great. Well, he's coming out, and there's Mr. Abate. A bunch of folks on the call. Normally they don't, if they're here to watch, then they should do Zoom. If they're here to talk, then we'll keep them, I'm sorry, if they're here to watch, they should be on the YouTube feed. If they're here because they're going to be sharing something, because it's a bond hearing, then I'll keep them on. So I don't know if Lamira Jackson, is that someone who's going to be testifying?
Not, well, this is about revocation hearing, Judge, so, I guess most of the witnesses will be the states. I didn't anticipate calling anybody, it's on them.
Okay.
I didn't anticipate calling. I think that's his mom. Yeah, that's his mom, top right corner.
Okay, and who's Marilyn Reed?
Hi, sir. I'm Quentin Tavis' grandmother.
Okay, thank you. And who's Javius?
Quentin's uncle.
Okay, thank you. So you folks, there's a YouTube feed that will show what's going on, and it'll be audio. It's basically everything you're looking at right now. Mr. Abate, were you planning on calling as a witness any member of Mr. Jackson's family?
No, Your Honor.
Okay. Then I'm gonna let them plug in via the YouTube feed. Great. Okay. There's the witness stand. You ready? Forte. All right, so our first matter is 18 SC 162228. It's State versus Quintavious Jackson. Mr. Jackson is here in court. Good afternoon, Mr. Jackson.
Good afternoon.
How you doing?
Good, how are you?
I'm well. He's represented by Mr. Bowles, who is seated by Mr. Jackson's side. And representing the state for this revocation hearing is Mr. Abate. It did say on the calendar bond hearing, and I was looking to Mr. Bowles thinking this was our traditional bond hearing where Mr. Bowles would be asking for bond. Mr. Bowles has reminded me that this is a revocation matter. At least that's how he's framed it. So I guess I just need someone to set the stage. The calendar indicates that Mr. Jackson has a $70,000 bond, but here he is wearing the jail outfit. And I'm just trying to reconstruct. It may have been that you, Mr. Bowles, and your client came into court and we had to take Mr. Jackson into custody. So why don't you remind me what that setting was, and then I'll figure out who needs to be arguing what.
Okay, Judge. Yeah, when we were here before you last time, we were here for revocation. The state had already secured a warrant for Mr. Jackson's arrest. When he arrived, he was taken into custody.
Okay, so given the warrant, he had to be taken.
He had to be taken into custody. Your Honor said that, well, being that he was taken into custody that day, then we can do the hearing at a later date.
Okay.
So that's why
So if there's a warrant for his arrest, what is the state? I mean, unless you're challenging like the technical validity of the warrant, if the warrant is for new charges, or the warrant was because someone had agreed that his bond should. Let me ask Mr. Abate what he thinks is happening.
Okay, sure.
And thank you for filling in for Ms. Convery.
You're welcome, Judge, I apologize. I believe there were two warrants, a probation, warrant, because a petition to revoke his probation has been filed. I also believe there was a warrant for this new case, which is the basis for, I guess, the petition from the state.
Okay.
So that doesn't make sense. So let me back up, and I apologize, Your Honor. I believe there was just a warrant for the new charges he had gotten for the entering auto that occurred on 8/26 of this year. Based on those new charges and the warrant for those new charges, Ms. Convery then filed a motion to revoke the defendant's bond on the 18 SC 162223, and I believe that was filed on September 28th of this year, Your Honor.
Okay.
The only warrant that was outstanding was the warrant for the new charges for the pending case that has not been indicted yet.
Okay.
Correct me if I'm wrong, Mr. Bowles.
Just that there's no probation ever involved, and he's not on probation, and there's no pending probation warrant. But everything else, Mr. Lonnie said is correct. He was arrested on the, I think it's an entering auto warrant, that by taking some similar charges, and that's why we're coming back here for the actual revocation. I guess Your Honor is about to go into the what is the substance of us being here, and it's to address the revocation. That's the base of the revocation is the warrant he was arrested on even before the last time.
Okay. I'm getting up to speed now. I see Ms. Convery's motion to revoke the bond that was filed when Mr. Abate said, and it alleges that in September of this year, Sandy Springs Police obtained felony warrants for your client's arrest for aggravated assault against a peace officer, entering auto, reckless driving, hit and run, etc., involving a rental car situation from August of this year. Your client was allegedly the front seat passenger in the car of a car used, and those are the details. It doesn't matter, there's a warrant. And what the state argued in its motion was, hey, it's a condition of your bond, Mr. Jackson, that as it is of everyone's bond, that you not commit any further violations of the law, and here's this warrant. So I entered an order, which I'm happy to reconsider, that says I've been presented with a felony arrest warrant that's inconsistent with the terms of and conditions of the bond. And so in October, I entered an order revoking Mr. Jackson's bond because he had been arrested on a felony warrant, and that arrest was a violation of the terms of his bond in this case. Given this new arrest and these new charges, I find that Jackson's bond should be revoked. So I entered that order, and I guess we need to work through that because in some respects, the merits of the arrest warrant aren't really what's before me. He's got these new charges. Getting new charges is a basis to revoke a bond. If you think that's not a proper basis to revoke a bond, I certainly want to hear about that. And part of the argument may be because these things never happened, or whatever you want to argue. I'm not trying to shift the burden. I'll hear from Mr. Abate, but I think the centerpiece of the state's case has already been presented, and that was a warrant that we actually confirmed when your client was in court. I was not interested in taking him into custody on word of a warrant, but I'm remembering now we had several sheriff's deputies reach out and confirm with their systems that there was an active warrant or warrants all related to this one incident for Mr. Jackson, and that's why he was taken into custody. So I guess what I'd like to do is start by hearing from you, Mr. Bowles, as to why either that warrant's not a sufficient basis, and so then the state needs to provide more, or if there are other reasons why you think the order revoking the bond that was entered I signed it on the 16th, it didn't get entered till the 19th, so maybe that was a Friday to a Monday or something. Why that ought to be undone?
Okay, good. Well, basically, my argument would be, I guess it kind of amounts to well, first, let me start by saying, I know the condition of the bond is that he doesn't get arrested. However, and I've never really had to encounter this, what is the substance of him being, what is the threshold of, is it just arrest, supposed arrest not to nothing? So I guess what I was thinking, maybe this is gonna be similar to a probable cause hearing on the warrant, to make sure that it's a good warrant, and make sure that at least there's probable cause. I know we're not here to decide reasonable doubt, but, I figured we were just gonna be doing a probable cause type hearing, to see if that warrant, which will be the basis of the revocation, is valid. I don't know exactly the circumstances of that happened because I was not present when the warrant was sought. So I don't know if there's already been a hearing before a judge, or I assume there's been something, but I was not present for that. But I just thought, and the officer was here last time, I just thought that that's pretty much what we're gonna be doing to see if the warrant is actually a good warrant.
Okay. Mr. Abate, anything you want to say in response to that?
Just only, obviously, I'm trying to get up to speed, like Your Honor was just getting up to speed, and I would agree or echo something that you said prior to Mr. Bowles' argument, that the basis for the actual revocation of his bond was a judge signing the warrant for his arrest for the new charges. I would agree with the court in that proving, probable cause or the merits and the facts of that warrant are not required in order for his bond to be revoked, as Your Honor has already revoked his bond. So I would agree that, I guess the next step of the next necessary step would maybe be an additional bond hearing on the charges, or for the case in which his bond was revoked, for Your Honor to reconsider based on if there's any change in circumstances. But I would agree with Your Honor. I don't think a probable cause hearing, so to say, is necessary in this sense. Is not the appropriate place or time for that.
Okay. I understand, Mr. Bowles, your approach to this, because what would often happen if the only reason why Mr. Jackson was in custody was the arrest behind the warrant or the complaint. Let's say there was a complaint. It usually happens in tandem. You'd be asking for a bond and there'd be a probable cause hearing. So a judge could determine, is there a basis for this complaint that is keeping Mr. Jackson in custody? But we've got that additional layer here of Mr. Jackson's already been indicted and had a bond for the case that we're here for today. And it is the fact of a warrant being sworn out, and not so much that Mr. Jackson was arrested. He was arrested when he came in here, but that warrant being sworn out is the basis for the revocation of the bond. And I don't believe there's a requirement that the state provide probable cause for that warrant. It's been provided because a judge signed it, or that we do, you and Mr. Abate and I, a probable cause hearing in connection with the new charges. That needs to happen, and Mr. Jackson's entitled to that. And the outcome of that could affect what's going on here. But I don't think that I wouldn't be the right judge to have the probable cause hearing, if you know what I mean. You have to do it twice. If you are trying to get a bond for the new charges, there would need to be a separate magistrate who's hearing that and ultimately handling the probable cause hearing. I'm trying to look Mr. Jackson up. I've got our case on the screen. Jackson's a pretty common name, but his first name is Les, so I may be able to see what the status is, if there is even a CP number, unless you already know that.
He already has, he was granted a bond on the warrant case.
Oh,
He was
okay.
granted, yeah, so basically he's being held on the state's revocation motion.
Do you know what the case number is for what we're calling the warrant case?
No, I do not.
Yeah, right there.
I'll see if we can look it up. Here it is. So for your purposes, it's 20, you want to write it down, CP 194832.
In charge of this entering auto.
It is now just entering auto. That's not what was represented in the motion that I got to revoke the bond. And on the 17th of October, Mr. Jackson was given a $30,000 good bond by Judge Hughes. And it was stay away from an address on Roswell Road and no contact with a victim. Okay. So Mr. Abate, what's your thought now? Mr. Jackson has a bond on what has become an entering auto allegation and not aggravated assault on a police officer, et cetera. I gotta go by what's in the complaint. And he's got a bond on that. I don't know what was shared with Judge Hughes, but she saw fit to grant a bond.
I think the state's position, well, not I think, I know the state's position, after speaking with Ms. Convery, would be that the defendant remain in a no bond status, or the revocation of his bond on this case remain revoked, and he remain in a no bond status. I can be candid with the court and to defense counsel, after speaking with some detectives at the Atlanta Police Department and Detective Dwyer, who's sitting to my right in the jury box, has also confirmed with some detectives at the Atlanta Police Department that they are very shortly, when I say shortly, I don't know if it's today or tomorrow, I'm going to be taking up additional warrants for a spree of entering autos that the defendant and his co-defendants were also involved in while he was out on bond for this case. I know that's not evidence that the court can use to revoke or not grant a bond. I want to bring to the court's attention because this may just be an exercise in futility, as the additional warrants are very forthcoming.
Or an exercise in repetition. I mean, I don't control what a magistrate's going to do, and Mr. Jackson might be back in front of one on the new warrants. Maybe after a while they'd say, well, look at all these warrants, we should stop giving them a bond, but not my call. So I think what would help me, and I don't know if you've got the right people here, by which I mean maybe it should be Ms. Convery, not you, because she's more familiar with it. Maybe it's this detective, maybe it's someone different. It would help to understand a little bit, and this may be going more towards the probable cause, although that's not the finding I'm going to make or that I need to make.
Yes, sir.
To understand some of the alleged conduct that prompted the warrant that resulted in Mr. Jackson's arrest and then this new $30,000 bond. So he's got $100,000 out there in the bond community. Because I think that's what will drive my decision. To Mr. Bowles' point, you got a bond on the other one. And so we're not in a situation where my decision to reinstate the bond or not would be moot because there's no bond on the new charges. Right. It actually would have significant impact. If the bond were reinstated, Mr. Jackson would be out for 24 hours, or however long it would be till these new warrants come along. But if what prompted the issuance of the warrant is something that I think justifies the revocation of the bond, then Mr. Jackson will stay where he is. So I guess that's what I'd like to do since we have everyone here, if we've got the right people. We certainly have the right people on the defense side, Mr. Jackson and his lawyer. Are you comfortable examining the detective to help educate me and Mr. Bowles as to what underlies We'll just call it the CP case.
I am, Judge.
Okay.
I've spoken to Detective Dwyer and I spoke to Ms. Convery
Okay.
this morning and a little bit. Oh,
Mr. Bowles, you comfortable doing that? I think it's what you were originally suggesting. And basically, the state has a burden now that I better understand that your client has a bond on these new charges, so there's not a warrant holding him anymore, then the state ought to educate us all as to what allegedly happened, and based on that, I can make a less mechanical decision of, there's a warrant, so you can't go anywhere. Are you all right with that?
I am, Judge.
Okay. Detective Dwyer, you want to come up?
Raise your right hand, please. Do you swear or affirm that the testimony you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name for the record and spelling.
Detective Peter Dwyer, Peter.
Thank you. You can speak.
And Your Honor, before we begin, I wanted to see what your preference was. Am I able to take my mask off during the questioning of this Detective Dwyer?
So both the witness and the questioning attorney, be it a prosecutor or the defense attorney, you're free to do that. If you're going to do that, what I'd ask you to do is stay at counsel table. So you've got the little screen there and use the microphone. Mr. Forte, off the record, do we know if the microphones are doing what they're supposed to do? Okay, then it should work quite well. Everyone is in the courtroom, so everyone will be able to hear you just fine who needs to, but I think our system is working such that folks who have expressed a clear interest in Mr. Jackson's situation will also be able to hear it through the YouTube.
Thank you, Judge.
You bet.
Detective Dwyer, where are you currently employed?
Sandy Springs Police Department.
And how long have you been employed there?
Just about 4 years now.
And can you tell the court where within the Sandy Springs Police Department you are employed?
I am assigned to the street crimes unit, which typically goes after pattern criminal activity.
And how long?
City of Sandy Springs.
Sorry, how long have you been there?
Just about a year and a half now.
And were you involved in an investigation that occurred on August 26th of this year?
I was.
And can you tell the court where and kind of what the processes were in that investigation?
Yes. So we, again, my unit typically handles pattern criminal activity. So we had a significant rise in entering autos and stolen motor vehicles from the south side of Sandy Springs.
Hold on 1 second. Oh, thank you, my producer. Hello, America. Sorry, my video wasn't on. South side, stolen vehicles, entering.
I was in the south side of Sandy Springs. So we conducted an undercover operation with a bait vehicle and items in the vehicle. High-end items were placed in the vehicle. On August 26th, we had a rental Jeep pull up and committed entering auto in the presence of 3 police officers sitting right next to it. On that date, we were not able to identify Mr. Jackson. However, we were able to identify the renter of the vehicle. And after
The renter of the Jeep.
correct.
Okay.
We identified the renter of the Jeep, and through interviews and a phone dump, he identified giving that Jeep to Mr. Xavier Smith and Mr. Quintavious Jackson
Okay.
at the airport.
And just to back up, when you talk about the bait vehicle, what kind of vehicle was that?
It was a Mercedes G-Wagon.
And was that G-Wagon, I guess, parked at 4600 Roswell Road?
It was.
Was that here in Fulton County?
It is.
For those of us who are not into high-end cars or can't afford them, what is a G-Wagon? That sounds like a government car, a G-Wagon.
It's a Mercedes, the big Mercedes SUV.
The boxy looking ones? Okay.
The one the Kardashians drive?
Yeah. The
Whoever they
rough value is around $200,000.
Okay. You just happen to have one sitting around at Sandy Springs Police?
Mercedes gave us one.
Okay.
And you said inside of that vehicle, you had placed some high-end items. Can you describe to the court?
Yes, we
what
placed
the
some
items
Louis
were?
Vuitton boxes, Tiffany's boxes in the front seat of that to make it more enticing.
And you said the Jeep pulled up, behind or near the G-Wagon or the Mercedes SUV. can you explain to the court how or what happened after the Jeep pulled up behind or near the G-Wagon?
So the Jeep pulled up next to the G-Wagon, the passenger got out, entered the Mercedes, and took 2 boxes from the Mercedes.
When you say injured, were any windows or anything of that nature broken, or was the car locked?
The car was unlocked. We saw the Mr. Jackson enter the front passenger or the front driver's side door, reach to the passenger seat and grab the boxes.
And after, I guess, the passenger entered back into the Jeep with the stolen items, did a chase or any sort of pursuit occur?
Yes, so we attempted to contain the Jeep in that parking spot, at which point it drove on the sidewalk at one of our officers and then continued and hit the Mercedes and then continued in a pursuit down Roswell Road into the city of Atlanta.
And just so the court gets a clear picture, the area of the 4600 Roswell Road is a shopping center.
It is a shopping center and it's about half a block from the city line, with the city of Atlanta.
Okay.
How did Mercedes feel about the fact that the G-Wagon they let you borrow, you had something crash into it?
They fixed it, so.
Somebody's gonna get a good deal.
Yeah.
So you said, so after the pursuit, you said you continued your investigation and you were able to identify the renter of the Jeep.
Yes, we identified the renter of the Jeep as Mr. Robert Chambers.
And is Mr. Chambers, how is Mr. Chambers related to or know the defendant, Mr. Jackson?
He is his local, I believe.
Okay. And were you able to speak with Mr. Chambers?
Yes, I took a warrant out for conspiracy with Mr. Chambers. He then agreed to waive Miranda and speak with me and agreed to be consented to a dump of his cell phone. At which point we found out he was talking with Xavier Smith, who was the driver of that Jeep.
Is
And
Mr. Smith related in any way to Mr. Chambers or Mr. Jackson, or just an associate?
He's an associate.
And upon, I guess you were learning of Mr. Xavier, does he have a nickname?
Zay.
After learning of the identity of Zay, what did you do next?
We then obtained warrants for Zay after we had enough public cause and that he was the one driving the Jeep.
And after that, what were you able to place him in custody?
We were. He was arrested by the U.S. Marshals in Fairfield.
And after-
Why was it that you assumed that it was Mr. Smith driving the Jeep rather than Mr. Jackson, if all you got from Mr. Chambers was, I lent my Jeep to Zay?
So on that date, Mr. Chambers stated to us that he had rented the Jeep and given it to Zay, and Mr. Jackson had pulled up in an Audi that day.
Mr. Chambers gave you that information?
Correct.
Okay.
We were also able to obtain, after speaking with APD, that Mr. Jackson's mother had been renting vehicles and Mr. Chambers had been renting vehicles for them to commit their office up and down Roswell Road.
And upon the arrest of Mr. Smith in Fairburn, were you able to speak with him?
I did. I interviewed Mr. Smith and we also seized his cell phone during that time.
And during the interview with Mr. Smith, did he provide you with any information about what occurred on August 26th?
Mr. Smith admitted to being the driver of the Jeep involved in that incident. He would, however, not tell us who the passenger was. We learned who the passenger was through his cell phone once we obtained a search warrant for it.
And when you obtained a search warrant for a cell phone, it was dumped. Can you tell the court what information you found in order to identify Mr. Jackson as the passenger and the person who entered the Mercedes?
There was a relevant text exchange between Mr. Jackson and Mr. Smith stating that they had been involved in a chase and they should, and if they should tell another individual, Mr. Chambers' son, Tyrell, who is a friend of theirs, about the chase.
And the messages or the chain of messages that you were able to see from the dump, did they occur on the day or shortly after, maybe the next day?
They occurred several hours afterwards.
After the chase?
Correct.
And after, I guess, finding that information inside of Mr. Smith's cell phone, is that when you then took arrest warrants out for?
We then obtained a search warrant for Mr. Jackson's phone records, and we then took an arrest warrant out for Mr. Jackson.
And were you able, have you received, I guess, the cell phone records of Mr. Jackson?
Yes, we received the cell phone records and mapped him to be at 4600 Roswell Road during the time of the incident.
And after Mr. Jackson was placed in custody, did you have an opportunity to speak with him?
I have not had an opportunity to speak with Mr. Jackson.
Okay. I don't think I have any. Well, have you also had an opportunity to, I guess, review this case and with Ms. Comder?
I have.
And are you familiar with the Instagram account for the defendant, Mr. Jackson?
I am.
Okay. And on September 9th of 2004, what is the handle for his Instagram account? Do you remember?
I believe it's B&B Lil Quint.
You say that one more time?
B&B LIL Quint.
And just to inform the court, the only reason I'm going through this part is because this was part of the motion to revoke bond. Ms. Conner had alleged in the petition that the defendant had a firearm on his Instagram account in September of this year, which would be in violation of the bond, as well as he was pictured with his co-defendants after he had been granted bond for the 18 SC case in front of Your Honor, which is also a violation of the bond.
Okay, let me pause you for a second.
Yes, Judge.
Detective Dwyer, were you one of the officers who was maintaining visual contact with the bait vehicle?
I was.
And were you able to see who got out of the Jeep and got into the Mercedes, or were you not in that position?
I was not in that vantage point. The officers that were in that vantage point could not positively identify Mr. Jackson either.
Okay.
And actually, I'm going to withdraw any questions about the Instagram account because his bond has already been revoked, so it would really be moved for Your Honor.
Okay. I think what's going to move the needle one way or the other is what we're talking about right now, as opposed to a picture on Instagram. Although, if I decide to reinstate Mr. Jackson's bond, I will reinforce the need to comply with those other conditions.
Yes, Your Honor.
Mr. Bowles, do you have questions for Detective Dwyer about this situation?
Yes, I do, Judge. Good afternoon, Detective.
Oh, sir.
So you were present at the time the bait vehicle was being used?
I was.
This was on Roswell Road,
It was.
but you did not have a visual of the person or persons who got out of the vehicle that drove up?
I did not.
Okay. Now, you said you came to identify Mr. Jackson as the passenger because of text messages between him and Mr. Smith?
Correct.
What exactly?
Along with Mr. Chambers,
Oh, Mr. Jackson.
stating that Mr. Jackson was present when he handed the Jeep over to Mr. Smith.
Okay, so he was present when Mr. Smith had took control of the car.
Correct.
Okay. What was it that was said between Mr. Jackson and Mr. Smith that indicated to you that he was present when this vehicle was entered into?
If I remember correctly, I'm not going to be able to quote it verbatim, but I believe he said, "Are you going to tell Bullet we were in a chase?" And they used the term "we" as in they were in the car together.
Okay.
And Bullet would be,
Tyrell Chambers.
who is the son of Mr., remind me,
He is the son of
of
Robert,
Robert Chambers. Okay.
and I believe Mr. Jackson's cousin.
But was it Mr. Smith who was supposed to be the driver of the rental car?
That's correct. But Mr. Chambers gave the rental car to Mr. Smith.
Mr. Chambers gave the rental car to Mr. Smith, but the text messages said something about Mr. Jackson being in the car with Mr.
Smith.
Smith.
Correct.
Okay, now, what about the text messages told you that this was from the incident on, and I think it was the 26th,
That's correct.
August 26th? What about the text messages said, we're talking about this incident right here on the 26th and not some other incident where we was doing something we shouldn't have been doing?
Because there was damage to the Jeep during the pursuit, they were in the text messages talking to each other about telling Tyrell or Bullet about the damages to the Jeep. And they used the term "we" several times, if I remember correctly. I don't have them in front of me.
Okay, so what indicated to you that it might be from that day is you think there was damage to the Jeep on that day, and they talked about damage to a Jeep.
They're correct. There was damage to the Jeep on that day, and they were talking about telling Tyrell about the damage to the Jeep. And Xavier Smith asked Jackson to tell him because it was his cousin.
Okay, did you ever seize that Jeep?
No, the Jeep was not recovered by us.
Okay, so if the Jeep was involved in anything else post this entering auto, you wouldn't know about it, correct?
I wouldn't know.
Okay.
However, based on the text messages, it was parked in a parking garage in Cobb County and then towed from that parking garage.
It was parked in a parking garage in Cobb County. Okay. So if it had been in an incident in Cobb County, you would know about that.
I believe I would, based on the fact the Jeep was reported stolen. And we had checked, we've been in constant communication with Carrollton Police about the Jeep.
No, let me rephrase. What I mean is in the time from this incident, August 26th, to the time that the Jeep was, I guess, picked up at the Cobb County parking lot, you don't know what that Jeep was involved
I do not.
in. And you don't know who actually maintained control of that Jeep between August 26th and when the Jeep was in the car parking lot.
Correct.
The text message between Mr. Jackson and Mr. Smith didn't specify any dates, did it?
I do not believe so.
Okay. The text message between Mr. Jackson and Mr. Smith didn't specify anything about, I think you said Louis Vuitton bags and Tiffany bags?
They did not.
So essentially, the reason you took out the warrant, Mr. Jackson, was because the text messages said the Jeep had been involved in whether or not we should tell Mr. Chambers, and they had been involved in something, whether or not we should tell Mr. Chambers, and also that Mr. Chambers said that at some point he had given the Jeep to Mr. Smith and Mr. Jackson was present.
Correct.
Did he say what date he gave them the Jeep?
He gave them the Jeep on August 26th around 4 p.m.,
On August 26th, around 4 p.m.
which is approximately 5 hours prior to our incident.
So from the time that you have knowledge of him giving them the Jeep and the time that this incident happened, we have a stretch of 5 hours.
Correct.
Do you know if, excuse me, if Mr. Smith is still in custody?
He is.
In what jurisdiction?
Here in Florida.
Are you able to tell us how many people were in the car that went into the Jeep Wrangler?
2.
Just 2?
I believe so, yes.
Okay. But, let me ask you, were you in a position where you could identify how many people were in this Jeep?
I was not in a position where I could identify how many people were in that Jeep.
I'd love to know. Thank you, sir.
Any redirect, Mr. Abate?
Through your investigation, have you been able to speak to other officers or detectives that were in eyesight of the vehicle, were able to confirm there were only 2 people inside of the vehicle?
Correct. Based on what I told you earlier, the Jeep drove straight at one of our officers. And at that point, he only saw 2 occupants of the Jeep.
And just to be clear, after Mr. Smith was arrested, you were able to speak to him post Miranda, correct?
Correct.
And he agreed to speak with you?
He did.
And did he admit to being in the vehicle?
He admitted to driving the Jeep.
And did he admit that he had a passenger in the vehicle?
He did admit to having a passenger in the vehicle.
But did he refuse to give his passenger or his name?
He refused to give the passenger's name in the interview.
And I don't have any further questions.
Nothing further, Judge.
All right, thank you, Detective. You can step down. Appreciate you being here.
You guys don't have any further witnesses?
Okay. I'm not going to find Xavier Smith in the system right now. All right, anything else you want to present, Mr. Abate?
No, Your Honor, nothing further from the lawyer.
Mr. Bowles, anything from Mr. Jackson's side?
No witnesses, Judge.
Any argument you want to make?
Yes, Judge. Basically, we're here for the warrant that was taken out on Mr. Jackson due to this entering order. However, I find that the evidence against him is weak. Basically, what they're saying is, we took out a warrant on him because we saw a conversation between Mr. Jackson and Mr. Smith about some incident that happened. Curiously, he also said that there were, and the state also said that there were numerous incidents on Roswell Road in that area of breaking into cars. And of course, we know that happens all around the Atlanta area. And we know there are car chases all around the Atlanta area. The text message didn't specify anything about breaking into a car, didn't specify anything about a G-Wagon, or Louis Vuitton, Tiffany, or anything, any other material part of this crime. It just said something about, should we tell him about a Jeep? Didn't specify any colors, or what that Jeep specifically happened to or when. So, Your Honor, I don't think the state has met its burden as far as showing that this is a valid warrant. As far as I don't see enough probable cause in this warrant to sustain a warrant, which would mean then, therefore, that he has not violated his bond. Your Honor, I know there may be some questions because there was evidence presented. I would ask that if the court did find that Mr. Jackson was somehow in violation of his bond, that this court would limit it to revocation of 30 days. That's all.
Oh, you said for 30 days.
30 days.
Okay, got it. Anything you want to add, Mr. Abate?
No, Your Honor, I would just briefly respond to say that I believe there's more than enough probable cause for the warrant. I believe Detective Dwyer was able to provide evidence, phone records that corroborated the fact that he was at the incident location at the time of the incident. He was also able to corroborate, I believe, and I wrote it down, but what Detective Dwyer said also that should we tell him we got chased, and then was able to reference the fact that they was asking Mr. Jackson to be the person to tell Bullet because they were cousins, which is confirmed by what he was able to determine through his investigation by speaking with Detective Chambers, or excuse me, Mr. Chambers. So I would submit to the court there's more than a probable cause for this warrant, and there's more than a basis for the revocation of the defendant's bond. The state would request that he, respectfully request that he remain in custody at this time, and that he is not a good candidate for bond.
The text messages were obtained by exploiting Mr. Smith's cell phone, not the warrant for Mr. Jackson's cell phone, or because they were texting each other, they were found in both places. You're still under oath, so you can say yes or no.
Can you just repeat the question?
Sure. The text messages that we're all trying to parse to say it applies to the Mercedes-Benz incident, or it could have happened anytime afterwards up until you got Mr. Smith's phone. Did those text messages come from, did you, law enforcement, get them from Smith's phone or Jackson's phone or both?
We got them from Xavier Smith's phone and obtained search warrant for phone records for Mr. Jackson.
Got it. You just basically were able to put Mr. Jackson in a location because it was cell site location.
Correct.
Thank you. Okay. So first, I am not passing on the validity of the warrant. I know there's been reference to sufficient probable cause for the warrant. Someone else, I think, has already done that. I don't know what was argued in front of Judge Hughes. She set a bond in connection with what we'll call the Roswell Road incident. But I don't think it is my role to say good warrant, bad warrant. What I'm focused on is what is the evidence that Mr. Jackson, while on bond for the 18 SC case, charging him and several others with participation in street gang activity and possession of firearm. There's a trafficking heroin count. I don't know if that applies to Mr. Jackson or a co-defendant, but either way, while he was on bond for that case, has he engaged in activity that is violating the law? And I find that what I heard today suffices to allow me to conclude by a preponderance that he did. In other words, there's probable cause to believe that Mr. Jackson was part of this entering auto scheme. I now understand why the motion to revoke mentioned the aggravated assault on an officer. That's not what the state has brought now, but we've heard testimony that The Jeep was driven towards an officer. That's the officer who was able to say there were two people in the Jeep. No suggestion Mr. Jackson was driving that Jeep. Sounds like that was Mr. Smith who was driving the Jeep. But based on what I've heard about Uncle Chambers and the text messages, et cetera, I do think that it's appropriate to keep Mr. Jackson out of harm's way and keep cars out of his way until we can learn more about this. Two things though, Mr. Bowles, I'm going to make sure you get those text messages so that you can actually read them. That you may read them and say, I don't need to bug you again, Judge, but you may read them and there could be markers in there that make it real clear from your perspective that it's referring to something that happened 4 days later when Mr. Jackson was with his family in Florida, but they were asking him what he thought about the situation. Making that up, but I think you ought to be able to see those text messages because they're germane to the ruling I'm making. The second thing that I'll allow you to do is you may do some legal research and say, you know, Judge, the standard for revocation is clear and convincing, or it's something more than preponderance. And then we may need to rethink it because I don't know that a jury right now with just what they've heard would convict Mr. Jackson. I think your closing argument would convince them that there's reasonable doubt, but that's because we don't have the text messages. We don't actually have the cell site locations. I've heard what I found to be persuasive information from Detective Dwyer, but those are the two ends of the spectrum: probable cause and beyond a reasonable doubt. No, it's not beyond a reasonable doubt. I think probable cause is the right way to view this, but I may be wrong. And so if you guide us all to case law that says that's too loose a standard, then we should talk about it again. In the meantime, if Mr. Abate's forecast is accurate, this may be a moot discussion, or we'll be revisiting it again because there are going to be additional warrants heading Mr. Jackson's way. And I think it's smoother to let all that coalesce so that we could have a final conversation after you've had a chance to look at the texts and we've got these other warrants, because you may just say uncle after all the warrants. I don't know what they're going to say, and they may be utterly underwhelming, and you may have a lot to say about it. What is the easiest way, Mr. Abate, for you to get the text messages to Mr. Bowles in the next few days? Are they something that Ms. Condry would already have? Okay, so that I got a nod from Detective Dwyer. So if you don't mind, maybe by the end of the week, seeing if you could get to Mr. Bowles text messages. I'm not saying he needs the whole phone dump from Mr. Smith's phone, but you got a lot of traction out of the text messages, and I want to make sure Mr. Bowles has a chance to look at them, and you may want to disclaim them too.
Yes, Judge, and I will do my best to get them to him by tomorrow, but by no means it should be any later than Friday.
If it can't be by Friday, just let Ms. Nelson know by email and Mr. Bowles, and then we can think this through again. I don't want to delay reconsideration if there's a good reason to reconsider. But as I said, based on what I've heard through the detective's sworn testimony, I'm comfortable leaving things as they are. I want Mr. Bowles to have a chance to look at the texts. We also need to see what, if anything, is happening with maybe another set of warrants coming Mr. Jackson's way. Mr. Smith is not one of the defendants in Ms. Convery's case. I just looked at the names and I didn't see an Xavier Smith, a bunch of names, but unless he's got an alias, he is not at this point, a defendant in the gang case for shorthand.
That's correct, Judge.
Okay, all right. Mr. Bowles, anything else on behalf of Mr. Jackson?
Nothing at this time.
We will reconvene as soon as we could get Mr. Jackson back here if you decide that's what we ought to do after you've looked at the text messages and we see if there are other warrants coming. Otherwise, Mr. Jackson will stay where he is, and there may be some new matters coming in as well. We'll see what happens. Thank you.
Thank you, Judge.
All right. Thank you, Detective, for being here.
Judge, that concludes my business. Can I be excused?
Yes.
Thank you very much.
Thanks for covering for Ms. Convery.
Of course, thank you, Judge.
Judge, Mr. Pena tells me that you're going to have a conversation about the three co-defendant murder case, Andre Griffin, Mr. Cannon.
No, we are going to have a conversation about that, but that'll be a phone call. Hopefully you can be on it. Is Mr. Hudson the third lawyer? Yes.
Yes.
Yeah, Mr. Hudson's not available right now, I've heard, unfortunately. Hopefully he gets well soon, but you and Mr. Shepherd and Mr. Hudson and Mr. Pinion and I need to talk, just so we figure out, there are a bunch of motions swirling around, and you filed your classic, I doubt everyone else's, and Mr. Shepherd has filed his classic 18-inch stack of, I want to suppress DNA, even though there's no DNA in the case. So I just need to figure out, what do we really need to have? And which motions are ones where you want your client here versus on Zoom versus I waive his presence because we're arguing something that's largely procedural. But there are enough moving pieces that what I've asked Ms. Nelson to do is figure out a way to get all the lawyers and Ms. Nelson and myself on a call. It could be, doesn't even need to be Zoom, but just so we can hear each other, so we can map out what's the most efficient way to do this. It's hard getting people into court. And if we can do it in one sitting, especially if you have standing to piggyback on some of these suppression issues. And I don't know anything at all about the case. It may be that the search that Mr. Shepherd is trying to suppress is only his client, your client was 1,000 miles away. But that's what we need to talk about. So I don't believe, Mr. Pinion, we were going to be talking about that now. I know you and Ms. Nelson and Mr. Shepherd had a conversation, but I don't think, we're supposed to have a hearing tomorrow in this case. But I think we're not going to, because Mr. Shepherd was suggesting we try to consolidate things. And I agree with that. I suspect Mr. Pinion does too. So he has to come down here as infrequently as possible. How did you all leave it with Ms. Nelson?
We are gonna have a phone conference at, I guess that clock's wrong, at 3 o'clock.
Oh, look at that, 3 o'clock today. So that's an hour fast. I don't know that it will be at 3 o'clock today. No one consulted with me. I know it's hard to reach, but we may not be done with the rules meeting. But rest assured that there will be a teleconference. You'll be involved. I think Mr. Hudson should be involved, but I'm hearing he can't be involved right now. Because if his client, if he has motions on behalf of his client, you shouldn't need to argue them twice or bring the same witness in twice. I don't know what motions Mr. Hudson.
He does have a motion to suppress.
Everyone wants to set up, so he may have that as well, and we ought to argue that together.
Yes.
Because it'll help me to be able to, when one says, our defenses are completely inconsistent, and I can hear them say, well, actually, we all think it was Mr. Bowles' client who did it. Well, it's not a happy defense for Mr. Bowles, but if everyone else is saying that, it can be tried. So, we may postpone the 3 o'clock, partly because we may still be talking about Mr. Goolsby's case at 3 o'clock. You'll be notified when we're going to get everyone together.
Okay.
All right? Thanks. And the trial calendar, this multi-judge trial calendar, will be going out in the next few days. And you are blanking on the name, Trim. It's not Trim. That's Mr. Frank. You have a very, very old bank armed robbery case that Ms. Nelson emailed you about. You said the likely plea. It will be on that trial calendar. It's not till January, but you'll get an email from me and Ms. Nelson talking about how that calendar is going to work and what we'll need to do to be ready for it. I just wanted you to know that's the only case you've got on it. I think is one you've got with me. I don't think any of yours with other judges made.
Okay.
Wingo, is that the defendant's name?
Kente Wingo, yeah.
Wingo.
Yeah, he has 3 cases, 2 of them armed robberies.
Okay. Well, his 2 armed robberies are on, it's just because he's one of the oldest in jail cases we've got that fits the mold of could we try it sort of in a week and it's not multi-defendant, et cetera. So I didn't want you to panic when you got that down.
Okay.
We'll work through it. Thank you, sir.
Thank you.
Are you ready for Mr. Goolsby?
Yeah, I'll take the 30 seconds to get our papers in order. I'm ready.
All right. Will you bring Mr. Goolsby out, please?
Yeah, folks, I have a order regarding that motion from Michael Sutton earlier.
Yeah.
I had it on the floor, it's been fine.
Sure. And then you'll just get me another one if you learn that they say it's through the sheriff.
Yes, sir.
Great. Hello, Mr. Goolsby. All right, how are you doing? Good. Ready, Mr. Forte?
Ready, Judge.
All right, we're gonna go on the record in 18 SC 163712. It's State versus Goolsby. Mr. Goolsby is here in court with his attorney, Mr. Franklin. The state is represented by Mr. Kenyon. And we have, I think, two matters we're gonna work through today. There is an evidentiary motion, meaning we'll take evidence today. A motion to suppress identification that Mr. Franklin has filed on behalf of his client. And we also have a 404B motion that Mr. Kenyon has filed. I'd like to do that second because we can take the testimony, get our witness out of here, and then talk about the 404B. If that works does that work for you, Mr. Kenyon?
Yes, Your Honor.
Mr. Franklin, you all right with that?
Yes, sir.
Okay. Was there anything else, Mr. Kenyon, that you thought we were going to work through today in Mr. Goolsby's case?
No.
Mr. Franklin?
No, sir.
Okay. Then as I understand the motion to suppress, there is someone who was in custody at the time. We'll find out what her real name is during the witness's testimony. We're showing a photographic lineup. So it's not a single photo, it's 6 photos. And Mr. Franklin is arguing that the procedure was unduly suggestive. And we'll work through it that way. I trust you've received at least a copy of the photo lineup?
Yes.
Good, okay. So there ought not to be a surprise of here's the photo lineup for the first time.
No, I mean, unless it's something different, which I unexpected to be, like, I have a
Okay.
copy, but I have a copy of what I challenged.
Excellent. Okay, great. Then that's the setting I need to understand what's going on. Anything preliminary before you call your witness or witnesses, Mr. Kenyon?
No, Your Honor.
Okay, let's go.
All right, the state calls Detective Shepard.
Good afternoon, Detective Shepard.
Good afternoon, sir.
Come on up, please.
Please raise your right hand. Do you swear or affirm that the testimony you give the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your first and last name for the record.
Detective Jerry Shepherd,
Just spell it for me, please.
JARIONSHEPHARD.
And Detective Shepard, where are you employed?
The Atlanta Police Department Homicide Unit,
How long have you been employed there?
18 years.
And,
You've been with homicide for 18 or APD for 18?
APD 18, I've been a homicide about 6 years.
and are you post-certified?
Yes, sir.
Did you ever become involved in any capacity in the shooting death of a security guard, Scott Marthone?
Yes.
Was this case assigned to you?
No.
And do you recall, was there ever the occasion for you to show anyone a lineup?
Yes.
And did you in fact show anyone a lineup in this particular case?
Yes.
Where did that occur?
Leave the DeKalb County Jail?
Did you go to the DeKalb County Jail?
Yes.
Do you remember when this was?
I can't remember the exact date.
All right. And did you meet anybody at that location for the DeKalb County Jail?
Yes.
What I'd like to do, did you bring any lineup with you?
Yes.
And did you bring a photo line admonition with you?
Yes.
Have you ever met this person before?
No.
How did you know who, the jail has lots of people in it. How did you know who you were going to go meet?
The lead detective gave me the information and I asked me to go show a line.
Okay, so someone else had identified person X, who we're going to hear about in a minute, as someone who might be able to make an identification.
Correct.
Okay, and you were tasked to find that person and do whatever lineup procedure you're going to share with them.
Yes, sir.
Okay.
And Detective, did you record the interview with anybody at the cab?
Yes.
Have you had the opportunity to listen to that recording?
Yes,
It's audio only?
yes, sir.
First, I'll show you states 3. And do you recognize
Yes,
the
sir.
flash drive I'm showing you is states 3?
Yes, sir.
Right, did you listen to this flash drive today?
Yes,
And did you listen to the recording yesterday?
yes,
Does it fairly and accurately record the photo lineup procedure with the individual that you questioned?
yes,
And does it also include the lineup on this flash drive that you showed the witness?
yes,
I would-
So I'm clear, meaning there's a digitized version of the lineup on the flash drive, because there's no video of your encounter. It's an audio only recording. So there's a file on there that's the audio of the interview. There's a separate file that is a digital copy of the lineup.
correct.
All right, I move states 3 into evidence for this hearing.
Okay, so stage 3 is a combination exhibit that has both the lineup and the recording.
Yes.
Is that the admonition also?
Yes.
Okay, so everything.
Yes.
All right, any objection to stage 3?
No objection.
Stage 3 is admitted.
All right, now I'm going to show you states 1. And ask if you recognize states 1.
Yes,
How do you recognize states 1?
it's the photo lineup admonition.
All right. Is that a fair and accurate copy of the admonition you brought to the Cobb County Jail?
Yes,
Is your signature on states 1?
yes,
Does it fairly and accurately represent the document that you showed to the witness at the Fulton County, the Cobb County Jail?
yes,
And do you see any changes, alterations made since the time that you presented it to the witness at the Cobb County Jail?
no,
All right, that goes states 1 into evidence.
Any objection to stage 1?
No objection.
Okay.
Like, after looking at states 1, does it refresh your recollection as to when you went to the Cobb County Jail?
yes.
And when would that be?
July 27th, 2018.
And who did you meet there at the Cobb County Jail?
Miss Sabrina Blanton?
And was that the individual you went there to meet?
Yes,
Where did you have a conversation with her?
it was the Cobb County, they have a meeting room that they brought her to.
All right. And is stage 3 a recording of that meeting?
Yes,
I'm going to show you what I've marked as states exhibit 2. And do you recognize states 2?
yes,
Is that a actual printout of the digital version of what's on states 3?
yes,
If you just take a moment to look at states 2, is that 6 pages? 6 pages?
yes,
All right. And if you could, does it fairly and accurately represent the lineup that you showed to Ms. Blanton?
yes,
At the time that you showed it to her, I see some writing on the page that says number 3 on it. Did that writing exist on it when you showed it to her?
yes,
When you showed states 3, did it have the signature on it?
no, just the number 3.
All right. And when did the signature appear on states 3?
When she identified the photo.
Okay. And does it fairly and accurately represent what was shown to her and what she signed at that time?
Yes,
All right, I move states 3 into evidence.
Any objection? Well, I think it's 2.
I'm sorry, it is states 2.
All of which is on 3, but 2 is just the photo array or line.
Correct.
Okay, any objection to 2?
No.
Admitted.
All right. Can you tell the court what you did with states 1, the admonition?
I read it to Ms. Blanton verbatim.
Okay. And again, that's on the recording that you
Yes.
listened to? Did you read everything that's listed on states two?
Yes,
I'm sorry, I call it states two, but it's states one. The admonition.
yes,
And did she sign states one?
yes.
Was that before or after you read the admonition?
The first portion, after the verbatim statement she signed, after the photo lineup admonition is read and she viewed photographs, the second portion is signed.
Okay. I'll look at states one. And did you tell her that you're about to view a group of photographs to see if you can make an identification?
Yes,
How did you show her all 6 of the photographs that are in states two?
before the photographs were even shown, I, of course, introduced myself, advised her what I was getting ready to read to her in the whole process. I placed the photographs face down on another part of the table, read the photo lineup admonition verbatim. She understood it, then I instructed her to pick up the photographs and go through them.
Did you, in any manner, tell her who she should pick out?
No,
Did you know if any of the 6 photos included the suspect or the individual in the courtroom here today? Did you even know that that particular photo was in the 6-person lineup?
no,
Did you know who the suspect was at the time you showed the lineup?
no.
And did anybody speak with Ms. Blanton in between the time you read the admonition and she looked at the lineup?
No,
Did you know, Detective, why one of your colleagues thought that Ms. Blanton would know anyone in that set of pictures?
I didn't know the specific details. I just knew that obviously she was a possible witness or had some information about it.
Okay. So you knew very little. You went in, hey, can you pick anyone out of here?
Exactly.
That's it. Okay.
All right. And about how long did it take before Ms. Blanton wrote what is on states two?
I would say she looked over the photos maybe less than a minute before she identified the number 3 photo.
And was that documented on states one that she picked states, that she picked number 3 out?
Yes,
And did you threaten her in any way to make an identification?
no,
And did you force her in any way to make any identification?
no,
Like promise her anything?
no.
All right, that's all I have, Your Honor.
All right. Mr. Franklin?
Good afternoon, Detective.
Good afternoon.
So if I understood your testimony correctly, can you hear me?
Yes, sir.
Okay, if I understood your testimony correctly, it's my understanding that what you're testifying to today is that going in, you didn't know details or anything about the case itself for which you were administering the ID.
I had no idea who the suspect was.
Okay. And so you have no idea who the suspect was. You didn't know which one of the 6 photos particularly was the suspect.
Correct.
But you knew that a person who they believed to be the suspect was within the 6 photos, correct?
Possibly, yes.
Okay. And you knew that Ms. Blanton had engaged in a photo procedure with other APD officers before the one you were administering.
I can't recall any details involving Ms. Blanton and other police officers or detectives.
Do you recall what you knew about her interactions with other police officers going in?
No, I don't.
You knew that she had provided information to, I believe it was Detective Sajak.
The only thing I do is, CJ asked me to go show a lineup to, subject that was in DeKalb County Jail.
And when you administered this photograph procedure, who put together the photographs?
I don't remember exactly who put it together. I'm assuming it was Detective CJ.
You did.
That's correct, sir.
You didn't put it together. Someone else did. It would make sense that it's Ajax's case, but you don't know.
Correct.
Okay. And so whoever put this photograph, the six pack together, you don't know what information they were basing the collection of these photos on, right?
Correct.
You don't know if she had given a description of height, color, facial features, or anything.
I don't know any details.
Okay. Now, this was a procedure that was administered at the jail at DeKalb County?
Correct.
And was this just like an office that was set off to the side, or?
Oh, they have a meeting cell, I guess they use for lawyers that want to meet with their clients.
Okay.
And the police detectives that need to meet whoever, the inmates.
Now, typically, when you've been a police officer in some capacity for 18 years, right?
Correct.
And for the past 6 years at least, you've been a detective, and that's been with homicide.
Yes, coming up on 6 years.
In your experience, when you conducted lineup procedures, do you typically try to have those video recorded?
No, there's sometimes things we have to go about a practical reason for how we show the lineups. Video is not always available, but we do try to, for the most part, always audio recorded.
Okay. And did you inquire about the ability to video record this procedure?
Well, I knew the room wasn't video recorded, so, but that was fine because I knew it was going to be audio recorded by myself.
Did you inquire as to whether or not there was a place within that building that had video capabilities?
Just from my prior knowledge of DeKalb County, I knew that that room was not audio recorded, video recorded.
Your Honor, at this point in time, I know that Mr. Payne has admitted without objection the audio from the recording. May I publish it this time?
Sure.
I'm going to play up the first couple seconds and make sure that you can understand your voice, okay?
So this is possible. Are you planning on playing the whole thing, or you're jumping to a particular spot?
Just the beginning portions. It's about,
I don't mind either way. I just wanted to know if there's a specific thing you're playing, or if we're settling in. Or
yeah, I'm going to pause it after it gets to the point that I have a question for this particular point. You just identify, you heard yourself identify yourself, right? So,
no, I'm here because I just talked to some one detective this week. I'll pay for the doing pop-up, okay? I'm gonna show you some programs. First, I'm gonna get some information from you. The first thing.
Skip ahead. Skip ahead.
All right, I don't know much about the case, pretty much anything. So, I do know that you need to show a photograph. And I guess whatever the person is in question that you guys already talked about, I want you to let me know when I give you instructions from there, if you see that person.
Okay, were you able to hear what you said just now?
Yes,
So you made mention of the fact that whoever it was that she already talked about,
yes. Sorry to take the signal.
okay? Whoever it was that she had talked about, set the stage at, maybe in the line.
Possibly, yes.
Okay, which is different than not informing her that anybody may be in the lineup. You made an affirmative statement that the person you talked about with the officer before may be in this lineup.
I'm not understanding what you're saying. We're showing the photo lineup. Reason why I'm showing the photo lineup because it's possibly a person in question in that photo lineup.
Okay, and in order to do that, you read that little admonition on that piece of paper that you have in front of you, right?
Correct.
And then it includes language that has been tried and true and tested that describes the person may or may not be in the line, right?
Correct.
That doesn't have to, that paper doesn't reference any prior conversations with any other investigators, right?
Correct.
So at this point in time, what you can tell us that you knew that there had been a prior conversation between Ms. Bland and some earlier detectives about an identification, right?
As I stated earlier, Detective CJ advised me to come to a lineup.
Okay, I'm gonna ask you to answer the question I'm asking as opposed to what you want to say. What I'm asking you, based on what you heard yourself say just now, you knew that there was a conversation about a particular person in the line.
Correct.
Okay.
You know, that you need to be shown the photograph. And I guess whatever the person is in question that you guys already talked about, I want you to let me know when I give you instructions from there, if you see that person, okay? Yep, so you see that person, okay, cool. All right, so I'm gonna see these face down right here. And since you're familiar with Carl line that admonition, I gotta read it to you verbatim, okay? Once we get through that, you sign, then we'll go through the procedure, okay? Are you about to view a group of photographs to see if you can make identification of the person who's involved in the crime now being investigated? This group of photographs may or may not include a photograph of the person involved in this crime. You should only make identification that you can do so. You may not talk to anyone while viewing the photograph. Since hairstyle, beard, and mustache are easily changed, the photographs you're reviewing may or may not depict a hairstyle or facial hair similar to that person who's involved in the crime being investigated. Also note that photographs not only depict the true complexion of the person, it may be light or dark in the show. Pay no attention to markers and notes depicted in any particular photograph. You understand?
Okay, so now we have the actual reading of the admonition, correct?
Correct.
So that would be somewhat redundant with the stuff that you said prior to that about the conversation with whoever the investigators who had previously encountered, right?
What do you mean redundant?
Redundant, it's saying the same thing twice.
I just read the admonition to
Okay, it's redundant. Now, we heard you also make mention, and you testified to this, that when you administered the photographic lineup, that you placed the photos face down.
her. Correct.
And I think you still have the actual lineup photos up there. So there were 6 individual photos on each on their own individual piece of paper, right?
Correct.
And the photos themselves don't take up the whole paper, they take up a small corner of the part, right?
Yes, photos on the top left hand corner.
Okay. So you didn't give them to her in a folder or anything like that, right? You just laid them down on the table face down.
Usually we either put them in the folder, lay them face down, either way,
Okay. And that's how you've been doing it for the past,
for years.
I'm sorry,
For years, yes.
past 3 years?
No, for years.
4 years, not FOUR, but FOR.
So when you administered the lineup, where were you when she looking through the photos?
We're sitting at the table, so I'm assuming I was sitting across from her.
Okay. So you didn't get up and turn your back or anything, right?
No,
Okay, and you observed her as she was looking at the photos?
correct.
Okay, and I believe, do you recall, I guess she kind of pushed the photo to the side or something, and you drew her attention to that and said, so you pushed the photo to the side?
No, I think she pulled the photo up and she looked at it and she put it separate from the other photographs. And that photo that she picked up and put separate was photo number 3.
Okay. And at that point in time, that's when we get into the, I guess, the conversation that Mr. Penny was having with you about having her sign the photograph at that point in time,
Yes,
right?
the next portion would be to, once she identifies the photo, that's when I give her instructions to go ahead and sign the photograph that she just identified.
Understood. Um, I believe that's it at this time.
Okay. Any redirect?
No, Your Honor.
All right. Executive Chef, thank you for coming.
Yes, sir.
So here you go.
Yes, sir.
Do you have any other witnesses?
No, Your Honor.
All right.
Thank you.
Thank you. Appreciate your time. Stay safe.
Yes, sir.
Mr. Franklin, any evidence you want to put up?
No, sir.
Okay, so the record is closed, and I'm happy to hear argument. I noticed in your motion, Mr. Franklin, you had concerns about the process, which you've heard about, so you can highlight what you want to highlight. You also alleged that what you call the filler pictures, the other 5, were sufficiently dissimilar to Mr. Goolsby's appearance that they might make the process suspect. You don't need to elicit that from the witness, of course, the pictures are the pictures. And you may have had a black and white version, and in the color version that you have now, you see that that's not the case, but I'm happy to hear about either concerns that you got.
Yes. So again, I'll pass the photos to Your Honor. You can look at Mr. Goolsby's photo, which of course is noted with the number 3 and the signature of Mr. Blanton. I didn't engage in any questioning of Mr. Shepherd about the photos themselves because he wasn't the one who put them together.
So this is states 1 or 2, this is not your, okay, states 2. Great.
So the court needs to look at the photos of Mr. Goolsby and kind of put that in one area and then lay everything out and look at them at the same time. I think it's pretty clear that there's a lightness and glare that's more apparent from Mr. Goolsby's photo. Based on evidence that we have, we don't know what information was used in terms of it's a brown skinned black male, it's a male who is this. We don't know what was used to decide photographs. What we know from evidence is that there had been conversation between early detectives about who committed the crime, and that there was a procedure that had been done before. We know this because she said, I've done this before and I'm familiar with the photo definition. So she had looked through photos before and did some other procedures. From other evidence, I know that, but because we're kind of within the corners of what we argue here today, I think we can fairly deduce from the evidence that she had engaged in the photo lineup before. They were there because she had not yet identified anyone. But we don't have any indication of what information was used to say, hey, let's find somebody who matches the description. And that's a best practice that when they conduct a photo lineup, as opposed to trying to find people who, quote unquote, look like the suspect, who look like Mr. Goolsby, they should gather photos that reflect a description or something of that nature, right?
So I will let you share with me your understanding of the evidence because Mr. Pinion can say, no, that's not right when it's his turn. At the time, so July 27th of 2018, did the police not know that Mr. Goolsby was the person of interest if it was just a guy with a clown mask? Or help me understand why they're getting in front of Ms. Blanton, why they think Ms. if that's the right name, why she's someone who would be able to identify the person who shot and killed security officer Marco.
Understood. I'll talk slowly, Mr. Payne, and I'll get into more details if necessary at this point, please stop. There were news briefings or something of that effect made. They were published. The public has saw them. Ms. Blanton had been brought into custody in the cab. Another incident had occurred at her home. I think officers came there searching for someone else in relation to it doesn't really matter.
But not the Waffle House robberies?
No, not in relation to that.
Completely unrelated?
Unrelated.
Okay.
From what she says in the video, I think she saw maybe the siblings or the family members of Mr. Mark's phone. And while she was in custody on the FTA, she decided that she wanted to help. I will also say that she made a statement in another interview that that it was said, like, if you want to get help getting these charges off of you, then these FTA charges, I'm not sure what the FTA was for, but if you want help getting them off of them, give us some information about this other situation that occurred at her home. Nothing was ever specifically mentioned about this set of allegations from Mr. Goolsby until she told a person working at the jail about it. That person got in touch with, I believe it was Detective CJ, or at least someone from Atlanta Police. They learned that somebody in the cab had information. They went to talk to her about, okay, so who is it? She gave a nickname of Casino. Casino, in our estimation, is somebody entirely different. It's a family member of Mr. Goolsby. Mr. Goolsby is known as Glenbo. His name is Glenn Goolsby. They call him Glenbo. So we don't believe Mr. Casino to be him in anybody's recollection. But nevertheless, she purports to have had an encounter where I believe she was dealing with somebody, I guess, like dating or talking, as people refer to it. A gentleman by the name of Scooney or Scooby. Couldn't really hear it clearly on the audio. She was dealing with this guy. That guy is supposed to be a friend of Mr. Goolsby. And that they were all in a car together at some point in time where Mr. Goolsby is alleged to have made admissions about having engaged in this murder. And we'll get into the 404B later, but he's also in that same conversation is supposed to have engaged in a confession to 2 armed robberies in the cabin on Panola Road in Wesley Chapel.
So Ms. Blanton's claim is that she would have information that would allow her to identify a suspect because she was in a car with the Waffle House robber.
Correct.
And she says it's Casino. The picture she picks out is your client, who could be Glenbo. That's a nickname you said he's used, but she picks out your client. And if she were here, if she remained consistent, she would say, well, I'm able to recognize that photo because I was in a car with him.
Yes, and additionally, she made mention that
she was dating a relative of
dating somebody. I don't think that the other person in the car, I don't think is a relative. Okay. I think it's supposed to be a friend or an acquaintance.
Okay.
Nevertheless, she also says that while making these admissions, that she saw a large rifle that she says looks like the gun that the deceased was photographed with in the picture. He was a security bodyguard at a recording studio. So he has this, I think it was an AR-15 rifle. And she said that she saw, I believe, that gun in the car. So she says she saw everything. And so she's not a witness to the actual robberies or the shooting.
Okay, she's not an alleged victim. No. She's not the Bonnie of Bonnie and Clyde. It would be this encounter, almost a chance encounter, that she says she had with the person she picked out. And the connection would have been the guy she's talking to, is maybe dating, is a friend of who she said is the guy who was admitting, I did the robberies and I killed the guy with the gun.
That is the story that she told.
Okay.
So one, the formation of the lineup, we believe, is unduly suggestive because we do believe that his photo stands out and that there's this shine to his face that's not present on anybody else's.
Why, just helps me sort of work through this. On what basis were the police traveling under the assumption that Mr. Goolsby was the person who shot Mr. Marthone? Or did they pick 6 random photos and it was a bad, really bad luck day?
I'm not clear as to how his photo got to be in this lineup.
Okay.
And this officer, understandably, he has no idea.
Yeah.
I know that there was a earlier lineup with some guys that actually had dreads. No pictures of Mr. Goolsby there. I don't know how they decided to get this particular lineup with Mr. Goolsby in it. That part I'm not clear about.
Okay.
So
So you don't know, and maybe Mr. Finney can answer this, but you don't know if, when, let's assume Sajak put it together. When Sajak put this together, if he thought, number 3 is the guy I'm suspecting, but I need some corroboration, because Blanton claims she had interacted with the gentleman. So let's see if she picks out number 3.
I know that in an earlier interview, and I'm trying not to get too much into the things that we testified about, but this was 27th, on the 24th, 2 lineups were done. And in the audio conversations of that, she makes mention that during a previous conversation with an officer, the name is not clear at that point in time. She makes clear that he showed her a photo. Like he pulled up on his phone, is what she said. So we kind of have 3 line of conversations, if you will. The 27th, which is what we're physically talking about today, July 27th. July 24th, where there was a lineup given that she didn't pick anyone. Actually, 2 of them actually, but the second was for somebody else they were trying to identify, figure out who the Scooby character was.
Okay.
In the conversation for the 24th, she makes reference to another conversation.
Where an officer showed her a picture.
Showed her a picture as she was, I guess she gave the story initially. That part may be a discovery. I was telling Mr. Pena earlier, I've been working my way through a bunch of calls and stuff. I don't think I overlooked it. I've only heard 2 lineup conversations. There's probably this third one before the 24th. But she at least references that she was shown a single photo at some point in time on the phone. So I don't know if he went back to that and used it as a basis for something. This is purely speculative, and I don't want to put too much weight on that part.
Sure.
More concerning as well. So we are very clear with how the actual lineup was performed. Not gonna beat up on Officer Shepherd too badly for the fact that he couldn't remember exactly how a conversation went 2 years ago. But he did offer testimony that was basically, hi, I'm Detective Shepherd. I'm gonna give you a lineup, yada, 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 and read the admonition. And we, through cross-examination, pulled out the fact that there was a bit more given that alerted her to this earlier conversation, which possibly she would have been as 3 days later, she would have connected the dots herself. But he specifically made mention of the fact that the person that you were talking about before may be in this lineup. And we think alerting her to that fact is improper. He made mention of the fact that he just put the photos down and he was sitting at the table with her and he put them face down and slid them to her and watch. OCGA 17-2-20 prescribes suggested procedures for administering live lineups, photo lineups, and show-up lineups. 17-2-20, I believe. Sorry, I'm getting it right. (17-20-2). I'm sorry.
Okay.
Subsection B, and it provides a live lineup, a photo lineup. The show-up policy shall include the following with respect to a photo lineup having an individual who does not know the identity of the suspect conduct the photo lineup, or who knows the identity of the suspect use a procedure in which photographs are placed in folders, randomly shuffled, and then presented to the witness so that the individual conducting such procedure cannot physically see which photograph is being viewed by the witness until the procedure is complete. There provides that it should provide the witness with instruction that the perpetrator of the alleged crime may or may not be present in the live lineup. That part is satisfied by the admonition. Use a minimum of 4 fillers. That part is satisfied. And they are supposed to, after a photo is selected, not only just have them sign the photograph, but also give an indication of confidence, not necessarily on a specific number. That wasn't done from what we've been able to figure out. And so the statute itself doesn't require or mandate the exclusion of evidence. Particularly, I think the statute was designed more so to encourage police departments to adopt formal policies themselves, to eliminate the way we do it, the way we've been doing it, so that it's a more predictable assessment for the courts. Detective Shepard testified that he administered this as he's always administered photo lineups. He's been doing it for 18 years. This statute went into place, I believe, July 1st of 2016. So however he's been doing it since 2003 should have changed per department policy at this point in time. So although there's not a requirement or a mandate that it be excluded per the statute, I think the fact that he didn't comply with what the legislature intended for the police departments to develop this policy, particularly brought up those things that are concerning about photographic lineup identifications and their reliability. So we're kind of making this joint argument that because we don't know that the photos were put together in a trustworthy way, that because this photo sticks out, that because the procedure, the questioning and the physical way that it was handed over do not comply with, I'm just gonna say best practices, that the identification procedure itself is unreliable and should be excluded.
2 questions I follow that. 2 questions. One, you referred at the very end as this not trustworthy way the photos were put together. And tell me what you mean by that. We don't know how they were put together.
Yeah, so-
I know you don't like the fact that Mr. Goolsby's picture is a little lighter than, it's a lot lighter than some, it's a little lighter than others. I get that. What's untrustworthy about, what's the untrustworthy part?
So untrustworthy may be a bit strong of a term.
Your defense attorney.
So yeah, so I'll find a better word. The certainty of it is unreliable. We can't really test it because we don't know how they came to put his photo in when the procedure that was, the process that was done before picture people that look totally different. We went from a lineup trying to find him that has dreads, he has dreads, to a different photo of stuff that doesn't, necessarily comply. So it's not as if, they find a picture of him with dreads, and I know hair doesn't determine everything. But it's not that they found a picture of him with hair that we know about, and they then just used a different photo that better comported to what she described him looking like. We just know that his photo showed up at some point in time, and through what we've discussed today, I feel comfortable asserting in my position that she made a statement to police before that someone had put up a photo on her phone, and that photo was Casino. And so it's just, we don't know the indicia of credibility. We don't know those things that make us believe that it's credible or honest. Not necessarily saying that because we don't know it, that it is dishonest or discredible or incredible, but because we don't know it's credible and we don't have the things to support its credibility, that should be an assessment that favors the defense.
Okay.
The final thing I would add, he also sat at the table as she did the procedure. He didn't walk away or get her to the room to kind of assess it without the inference that there may be pressure to pick somebody. And so that's another factor that is added on with all the other things.
Okay.
Thank you, Your Honor. I'll speak into the mic here. Your Honor, on this suggestivity of photos in a lineup, it has to be such that it's like signaling to the witness, this is the person that you're supposed to pick out. And I looked at that lineup, and I don't think anybody could reasonably come to that conclusion. It may be a little lighter, but there's nothing saying this is the person that you should pick out. I didn't even really see that it was that noticeably lighter. As to the detective saying this may, the person you've been talking about may be in this lineup before, that's fairly close to what the admonition, which you heard read to the witness, states that the person may or may not be in the lineup. And all he was doing was directing her to the previous conversation that she had, whereas defense counsel stated she had told police, hey, I know the guy that did this, seen it on the news, the victim's family, they're upset, and that's really terrible. I've seen the gun, it looks like it was stolen, and it had blood on it, and he was talking about robbing Waffle Houses. That's on the tape, because she gives the statement to the detective Shepard on there. So this was somebody she was familiar with.
You say it's on the tape, meaning after Ms. Blanton selects number 3, Detective Shepard does the follow-up interview with, well, who is number 3?
Yes.
And I'll listen to it, but she says, hey, it's this guy who had this gun, looks like a gun, has blood on it, he's talking about Waffle House.
Correct.
Okay.
Yes, yeah. She did get multiple interviews. She didn't know the name of the person, but she doesn't go through everything, but she does. She runs through it again. You can tell by the interview that Detective Shepard does not know anything about the case, so he just wants to get some details as to you're picking this guy out, or what did this guy
Right.
Why? Because they were trying to figure out, you'll hear on the tape, she said she was in the back seat with this guy that said his name was Casino, and he's showing her the gun and how he killed this off-duty, looked like police officer, robs Waffle Houses, and then there was another guy in the front seat, and so the police were trying to figure out who the driver of the car was as well. I think that was part of the lineups, but they were trying to zero in, they didn't have a name of the person, so it took on multiple lineups, which I think actually goes in favor too of the police, because they had done this before, and she actually didn't pick anybody out, and this time.
I'm sorry, keep going.
And then at this lineup, they're still trying to figure out who this individual was who told her about the Waffle House and killing and stealing this long assault rifle. And then it's like, oh yeah, this is the guy I know, and not a stranger ID, somebody she knows. So
Do you know if photo number 3 was the one that Sajak thought might be the person, or did Sajak just get 6 pictures of guys who fit the description someone gave at the time it was shown to Ms. Blank?
I am not certain of that. I know that she was trying to give them tips of certain criminal activity in the area. They were trying to figure out who's active in the area, and we're trying to zero in that way. And then she also was able to give a description of the car. So they're looking for somebody with that type of car. She's on the same, the car he's in has an August 5th drive out tag on it.
I guess I've never heard of a photo lineup put together where there's no filler in that scenario. All 6 are potential suspects.
No, in this one, he did, through his research of activity in the area and with that type of car, and looking at the Waffle House video.
I'm not asking, there may be 100 reasons why, but photo 3 was the photo that Sajak put in as, I think this might be it.
Yes.
And the other 5 are fillers.
Yes.
Okay, at some other time, in front of maybe a jury, he can explain why he thought it was Mr. Goolsby, but it's a very different analysis if this is just there aren't filters in it. If it was just 6 pictures of, you know what, we'll put the usual suspects in, and that brings up other issues.
Right.
So number 3, whether he, presumably he knew the names, looked like either booking photos or driver license photos. By the time Sajak asked Shepard to go to DeKalb County Jail to meet with Ms. Blanton, his first time, Shepard's, but not the first time people have spoken with Blanton, Sajak had begun to think that Mr. Goolsby was a possible suspect.
Yes.
Okay. All
And
right, what's the
yes.
rest of your argument?
That's basically it. The admonitions being given as far as best policies. This detective, maybe he could have left the room, but he didn't know who the suspect was. And you can also tell that by listening to the tape. So there's no way he could suggest to her who to pick out. And so him leaving the room was not as big a factor as if he knew who to pick out. And it's like giving her the stare at a certain photo. Having somebody that doesn't know who the suspect show the lineup is an excellent practice. We used to do the 6-pack, and then this isn't even the 6-pack, which is still appropriate, is not being thrown out because it's 6 at once, but it was actually 6 separate photos. And on the totality, there is nothing that led to the inevitable selection of the defendant in this line of procedure, and it should go to the jury for their consideration. Thank you.
You're welcome. Anything you want to say in closing, Mr. Franklin? You didn't already say?
Just a brief response to what Mr. Penny offered. I would assert that the fact that she didn't pick anyone in the earlier lineup is not really something that would lend more credibility to her selection of Mr. Goolsby in the lineup in question. I think, especially from upon my view of the others, there just aren't any photos that stick out among those 6 people the way that I feel that Mr. Goolsby sticks out in this particular lineup. So I think it kind of goes more so toward the fact that when we have a lineup that is more suggestive, that she's going to then say, I'm going to find somebody at that point in time. Because she didn't find somebody the first time. We know that she had this mindset of trying to help to some extent because she had this FTA she wanted off of her. And they came back, we know 3 days later, to do another lineup, and the officer says, the person that y'all talked about, might not be in here. And then he reads the admonition. So additionally, the purpose of leaving the room or turning your back or anything like that is to avoid the appearance of impropriety, such that as a person looking at the photos, the officer can give any kind of visual indication, which is why I went to the questioning about, did you at least attempt to see if there was a place where a video surveillance thing was in place so that we could see it being given? Because yeah, that's a great deal of things we can learn from the audio, but the same reason we want witnesses in court. Things are different when you are actually able to see the interaction alongside the words.
Yeah. So. Okay. All right, I will take this under advisement, and I will take the other exhibits. Where did they end up? That is 3. 1 is somewhere. The admonition. All right, 1 second, we will pivot to 404B.
And for purposes of this particular hearing, Your Honor, we'd like to invoke the rule of receiver session.
I don't plan on calling any witnesses for this. I'm going to proffer.
Okay. Can Detective Shepard go? See if we can go.
Oh, yes.
Okay.
If he wants, I think he was interested.
Okay. Do you not want Detective Shepard to stay for this argument?
I prefer he not be in the room.
Okay. Any issues with having him go?
Well, I don't know of any reason why he would have to go. He's just interested, but,
I mean, to the extent, I don't think, I'm not accusing Mr. Detective Shepard of ill will or ill intention, but there are things that may come out of trial later on that he's not party to through his lack of involvement in the case. I don't see any benefit of him still being here, but there is a slight possibility that it could negatively impact the veracity of his future testimony.
If Detective Sajak were here as the lead detective, because he's someone who just follows everything that happens with his cases, what would the basis be for having him not, there's no testimony that's happening? Unless you plan on calling
There's not any testimony, but I believe the nature of our argument is made. It's a second and sorry kind of thing.
Okay. You're free to stay if you want. Detectives are 100% up to you. You'd be able to get a transcript of this if you wanted to. I'm gonna let you stay because we're not calling witnesses to testify. If that changes, I'll revisit it. Let me deal with this one email and we gotta go. All right, we set the conference call with Mr. Shepard just 30 minutes ago. All right. Do you need a break, Mr. Forte, or are you good?
I'm good, Judge.
Let's turn to the 404B motion. As I understand it, Mr. Pinion, you are seeking to admit at trial of the murder, which involves, it sounds like attempted armed robbery or something at a recording studio. Is it pronounced Little or Lydell? The street where the recording studio is. L-I-D-D.
I'm not sure. I think people pronounce it different ways.
Okay.
I think it's Lydell.
That's how I always pronounce it.
Is that the street where it used to be Nick's and now it's the club on Peach Street near the Benihana's? Doesn't matter. I'm trying to figure out where, in my head, where Lydell is. Either way, it's in Fulton County, unlike the 404B materials, which would be two different, and Mr. Franklin and I talked about it, two different armed robberies of Waffle Houses, one on, I have the addresses here originally, but they were exactly what you said. They were near each other in DeKalb. They're not in
Panola Road and Western Chapel Road.
in Fulton County. And I guess I'm trying to figure out, the case in chief involves two addresses as well. There's a Waffle House on North Side, and then there's the Lydell Drive, where I guess Mark Owen was serving as a security officer. Before we get into the substance, it would help me understand what the connection is in your mind, Mr. Pinion, between the two events that are stapled together in the Fulton indictment are.
Your Honor, it is that this is a crime spree by the defendant. They're within a day of each other, July 10th and July 11th. Each time he's using a handgun in a armed robbery.
And we're talking about just the Fulton events, right?
Correct.
So our indictment, what we're dealing with, has the armed robbery of a Waffle House and then whatever happened at the recording studio. That's all one indictment.
Yes, Your Honor.
Okay. The Waffle House robbery, is it your understanding that the evidence would show that whoever robbed the Waffle House in the Fulton case was wearing a silver clown mask?
Yes.
Okay. And the shooting of Martha House, was that an event that occurred in between the three Waffle House robberies, two DeKalb and one Fulton, or was it first and then we had Waffle House robberies?
No, the
3 Waffle House armed robberies all occurred on the same day, July 10th, and then the security guard was July 11th, the next day.
The next day. Silver clown mask in that case?
No,
Okay.
not that we're aware. There's video, but you can't see.
But there's the
You can
grand.
see- It's too grand.
Okay.
I don't think so.
All right. And the reason why I'm asking all this in particular, Mr. Franklin, for your edification, part of my reaction in reading this was, how is this even extrinsic evidence? That's actually what 404B is called, is extrinsic evidence, something else that a defendant allegedly did, but it's relevant somehow to why we would be in court. And insofar as the case that goes to trial is the Waffle House robbery, I don't think the DeKalb Waffle House robberies are extrinsic evidence. I think they're intrinsic. And I think there's all sorts of case law that would allow the state to get the 2 DeKalb cases in if all we were doing was the Waffle House robbery. But we're doing more. And that makes it more complicated. So I do think we need to work through the analysis. Is there, you haven't yet decided whether you think you would argue for severance of counts.
I hadn't officially decided. I will tell the court that it's significantly more likely than not that I will argue that it be severed.
Okay.
The more that I fill the gaps on in the case.
Okay. But if you don't sever, then you understand that it could be that the jury would be allowed to hear about the DeKalb incidents and then instructed that they should consider that only in connection with the Waffle House piece of your case.
Yeah, the only assessment I have is my gut, of course, is to sever, but I want to make sure there's not a downside that I'm not conscious of.
Right.
I didn't want to irreparably change things and then like, oh God, I didn't think about this. So
You could always seek to rejoin the counts after you, because I assume the state would like to keep them together. All right. Well, I appreciate you guys indulging me on that. This could have been a real short hearing if Mr. Marthone had been a security guard at a Waffle House and was shot by a guy with a silver clown mask. Because I'd hear you out, but it would be coming in as intrinsic evidence. But it sounds like the Lydell situation it's a slightly different species of, if it was even a robbery, I don't know. In many ways worse, someone's dead. So why don't you do what you do, Mr. Pinion? Let me know what the case in chief is about. I think I understand what the 2 DeKalb incidences are about. They are certainly contemporaneous and they sound pretty similar, not that that's the test, to the Waffle House piece of the Fulton case. But if you think it should come in connection with the Lydell incident as well, you're going to need to help me understand for what purpose or purposes, and then the 403 perspective.
Okay, thank you, Your Honor.
Sure.
I filed this, if you look at the 404B motion, I actually spend a good deal of time arguing that it is intrinsic evidence.
I don't mean to suggest I came up with it all by myself.
Right.
You did.
Yeah, well, and that was just in case the defense filed for severance. So I didn't even really plan on addressing the 404B because I do believe it comes in as intrinsic clearly as to the Waffle House armed robbery. And if I just start out right there, the 3 Waffle House robberies, 2 of them were in DeKalb. The one on the indictment is in Fulton County. And if you look, the first, and I've put the police reports on here, on July 10th, 2018, the first Waffle House armed robbery came in to police at 3:45 a.m. That was on Panola Road, and it was a single black male wearing a black hoodie and lighter colored jeans, lighter than the black color, who came in went into a bathroom, kind of comes out with a silver mask on and a silver gun, a chrome gun, and robs individuals and the employees inside of that Waffle House. Then the next armed robbery happened approximately 20 minutes later. And that is on Wesley Chapel Road in DeKalb County. I Google mapped it, it's about 3 miles away. So again, we have a single black male kind of looking down, and I attached even some stills for both of those there, dressed the exact same way, does the exact same thing, goes into the bathroom, and comes out with a handgun and a silver mask on. The Fulton County one then occurred approximately just 15 miles away, and that is on Northside Drive here in Atlanta. That would be at 5:40 a.m. So all these occurred within actually a little less than 2 hours, seems at my math, and they're just traveling along a path that you would expect from DeKalb into Fulton County. It makes sense kind of along the freeways, possibly. I don't know, but they are in a line and very close, and they're within extremely close in distance, and they're done in the same way. The Fulton County one, I again went and looked through the discovery today and double checked. The witnesses state that a single black male comes into the Northside Drive Waffle House, goes into the bathroom, he's wearing the exact same clothing again, and comes out with the handgun and the silver mask and the black hoodie pulled up. And the only difference is that while he's doing that robbery, he actually shoots one of the individuals with that handgun. Fortunately, that person lived. In all 3 of the Waffle Houses, things are taken from the individuals, and then the suspect flees. So I see all that as intrinsically related, that clearly is a crime spree. If it was all in Fulton, they would all be on this indictment as well. I think I laid that out sufficiently that I don't need to go into more detail.
I agree. Let's shift to how the DeKalb incidents would be appropriately admitted if what we were trying was simply the half of your case that is the Lydell incident.
Okay. Well, Your Honor.
Which was the day before.
Yes, this turns into also on the definition of intrinsic, which I do lay out in here. This is the particular case where the murder is on the indictment, primarily because the evidence so overlaps that it is impossible for the state to present the evidence that put that, specifically the witness Sandra Blanton, and the evidence found in the car. It's the state's contention that when the defendant is arrested, he has items from both mixed in the car. The evidence that led to him comes from Sandra Blanton, who she contacts the police and says she has the information. She wants to be forthcoming, and her statement, and you'll hear part of it, it was introduced, is that there's a guy that she's known for 2 months. It's somebody she's been hanging around, a friend or cousin of his named Scooby. She says he was in the front seat of the vehicle, and they're riding around, and she could pick him out of the lineup. She just knows a nickname. That he's drinking one night shortly after this murder, and that they're in the back seat, and he starts bragging about how much money he's making robbing Waffle Houses. And that this actually conversations happens in DeKalb County, in Lithonia, which is near both these Pinole Road and Wesley Chapel. So then he says also I also shot and killed what he says is an off-duty police officer. And when you see the photos of the victim in this case, he has a badge on that looks like a police officer badge. He's actually extremely physically fit too. Is dressed like an off-duty police officer, and he's showing her the assault rifle he took from the security guard. He says, yeah, this was a security guard outside and this studio, and then he shoots him, and he said he stole his assault rifle, and he also his handgun. And the victim did have a handgun that was stolen and the assault rifle. The police don't find, when they stop the vehicle, and I think I've laid that out in the motion later on in the month, they find a clip to a gun that is exact match to that handgun and for the assault rifle. And then the deceased had bought an aftermarket laser red sight, expensive to put on the assault rifle, or one of them, I think it was assault rifle. They find a scope that's that exact model that we have where the victim had bought that. They find one that fits that, and she even described in her statement how he had a laser sight on one, and she said there's blood on it too, not on the rifle. And he's asking her if she wants to hold the gun, and she doesn't want to. So the defendant brought these two cases together. I don't know how she could be cross-examined. They probably would have to play her previous statement as at some point, to specifically see what she said, because she gave multiple statements to the police when she was trying to tell them who made this confession to her. The way that the information came to her, it was in combination. And he also told her he did the Waffle House robbery wearing a mask. I think I wrote down some more. So the confessions to all of these came together. In the vehicle, I did mention the scope and the two clips, one to the assault rifle, one to the handgun. They also find, I mentioned that there's video of the studio where the victim is killed, and you can see an individual come up to him that's wearing gray pants with a white stripe. Inside the vehicle, the police do find gray pants, some sweatpants, gray pants, white stripe. That's also in the vehicle when the defendant is caught, and they find it looks exactly like what you see in the still shots, a silver clown mask in the trunk. And I've had that DNA tested, and it does come back the defendant's DNA on the mask. And so all that evidence is found in that vehicle. When Miss Blanton, obviously she's in jail, and so her credibility is going to be attacked. What the state needs is to show that she is credible. And how we do that is, she says he's had in the vehicle a handgun taken from the victim, and we find a clip. He had an assault rifle, and he's got a laser sight. We find a clip to that type of assault rifle, and we find a laser sight. She says that he was talking about his clown mask, and that's found in the vehicle. And then additionally, she says the type vehicle it is, and that it has a August 5th drive-out tag on it. So once the police figure out that once she picks out Blanton Goolsby, then the police start putting a lookout for him, and that he's driving a vehicle, looks like a Grand Prix, a dark color, and has August 5th drive-out tag. Well, that's what led to them capturing him. That was all intertwined in her statement. So she's saying in the vehicle that he was showing me this stuff from the Waffle House and the murder is in a vehicle that has an August 5th drive-out tag. And I forgot to mention that also on the video of the homicide, you see what looks like a dark colored Grand Prix around the time of the homicide, and right after what appears to be the shooting and the 911 calls, you see that dark colored appears to be Grand Prix. It's consistent with that leave the area. So the police, when they blue light the vehicle, it turns out the defendant is driving and he starts a police chase, and then the car crashes, he ends up running, and they capture him. So her credibility, you can see that she has information that turns out to be correct. It takes some from the Waffle House and some from the murder intertwined. So it's not, we are not able to separate that evidence out. And we believe that the case law is citing that this is a particular type case where it's necessary to complete the entire story, being that she's right about this, a clown mask being in there. She's right about evidence of an assault rifle and a scope, and also a handgun in the vehicle. She's right about the drive out tag, because we can see that they're contesting identification that she made. So all these things show that the odds are just astronomical that she would be correct about all this. And we cannot show how credible she is without presenting the armed robberies in connection with the murder. And these are very close in time.
Was there an armed robbery component to it, or all you know is that the security guard was shot and killed, and you're saying Mr. Goolsby did it? Or was he shot and killed because he was trying to prevent someone from taking something from the recording studio?
Your Honor, the evidence is clear that was an armed robbery as well, because he is shot in the head, and then,
and then his property's taken. He was armed robbed, but is he just standing outside a recording studio? I mean, is there?
Yes, and the Sandra Bland, the one that picked him out, says that the defendant is bragging. The evidence would be that he's bragging about killing him. You know, at the time he's talking about the money he's making, and going, and I also got this, that, yeah, there was a security guard, and he was taking his job all serious, you know, and so he shot him and robbed him.
Okay.
So it was just, he said thought he was tough, you know, and taking his job too serious.
Okay.
So these are 3 armed robberies where items were taken, and then and you also have in the Waffle House armed robbery in Fulton, somebody was shot there. It's done with a handgun in all of these. Also, the defendant's cell phone was not in use at the time of the homicide. The 3 armed robberies, it was in use, and it tracks. It puts him at each one of these locations, and I think I put that in. Also, when you get to looking at it at a 404B analysis, I would say that this actually is one of the cases where it could go it's clear it goes to identity as to the armed robbery in Fulton. That is, it would be going into the restaurant around with clown mask. That's the signature crime. It also shows the intent to commit use force, and specifically a handgun to take items of value. I wanted to mention as to the 403 analysis, this is a case where it's the exact same witnesses, the primary witnesses. Now, you do have victims in the DeKalb armed robberies that would be additional, but the main witness is Sandra Bland, and she, I think it's Sabrina Bland, I'm sorry. I know who Sandra Bland is, but Sabrina Bland is the witness to both of these, and she's going to testify if it's armed robbery or the murder. And so for the orderly presentation of evidence, there's not many additional witnesses. We just have some victims come in and say, I was robbed by a guy wearing a mask, but there's video, so it doesn't need a whole lot of that. We're gonna have the cell phone evidence anyway. But primarily it's the orderly presentation of evidence, and we cannot show the complete picture. So I think the strong argument is that it is intrinsic, and otherwise as a 404B, again, I would say that it does show intent, and well, as to the armed robbery, I did mention it is a signature crime, so it would go to identity there. But severance at the time I filed this has not been even motioned for. So I filed, go ahead and went and did the 404B motion, just in case there was this issue to come about. But as it stands right now, I believe that these were joined properly as a shortened time crime spree for armed robberies in a 24-hour period, and that they should be tried together.
So to help you focus your remarks, you can cover wherever you want, but Mr. Franklin, here's how I'm seeing it right now. As to the Fulton Waffle House robbery, the cab robberies are coming. I'll give you why they shouldn't, but I see that as being crime spree, inextricably intertwined, etc. As to the Lydell incident, it's more complicated. If it's all one crime spree, they come in, or inextricably intertwined. On a pure 404B basis, it's not ID, because there's no evidence about a clown mask. There's nothing signature about same outfit, goes into the bathroom, comes out, robs people at a Waffle House. Those are carbon copy situations, unfortunately for your client, if it is his DNA inside the mask. But the Lydell one is different. It doesn't suggest the same motive, etc. Certainly not the same modus operandi. And so the best that I could tell from what Mr. Pinion was saying is, well, intent or motive. But I'd come down to that one, that just because you do an armed robbery here doesn't mean you do an armed robbery there. There's not the signature piece of it. So I don't know that there is a strong 404B argument as to the Lydell piece. And I share that with you. You don't need to spend a lot of time. I agree with you if that's what you were going to say. I'm interested in your view of Mr. Pinion's argument that you really can't pull apart the state's case against your client in a functional way, so that the jury would only hear about the Lydell incident. If you were successful in severing the two, why wouldn't all this other stuff come in anyway? Because it's how the investigation unfolded, and it would be close to surgically impossible to excise any reference to Waffle House stuff or other armed robberies. I mean, I'd say Waffle House to just talk about the Lydell situation.
So to begin, I think to me, it seemed kind of straightforward and obvious that you would just ask questions about those things that we're trying Mr. Goolsby about. And so if you're going to ask a question about the robbery here in Fulton County.
The Waffle House or the Lydell?
The Waffle House robbery, I'm sorry. I think that there was no conversation from Ms. Blanton's point of view about Mr. Goolsby robbing the Fulton County Waffle House.
I don't know how specific they got.
The admissions, I believe, were to something in the cab. And so that's a very easy line to draw, because you don't have to talk about the cab stuff, about the Fulton case. And I'm gonna kind of race to the end, because we've had a couple of 404Bs amongst yourself and Mr. Payne and myself. And I think it's interesting that each of those, we always have this really
interesting conversation about the necessity for it was certainly extrinsic evidence as it pertains to the shooting murder allegations. Testimony about Mr. Goolsby having committed armed robberies at Waffle Houses in DeKalb County is not necessary in a case where the state purports to have a confession, where the state has the mask that is supposed to be worn in the Fulton County robbery. They can just present the mask, testimony that the person had a mask, and show their evidence pertaining to DNA evidence. There's no need for discussion about anything involving DeKalb County because the state literally has everything that it needs to put forth the case.
So you're saying necessity, but what I'm hearing is effectively it has such a minimal, it's relevant, but it has such a minimal probative value, in particular on the Waffle House side, because they'll have confession and DNA. DNA is often lights out for jurors. What is DNA? They were done. I mean, why would you need to hear that they were under Waffle House situations?
Yes.
Okay. So it's a 403 argument that it's certainly prejudicial. If the probative value is so low, then it could well be substantially outweighed by that undue prejudice.
Yeah. So I don't concede, but I do see the writing on the wall in regards to the DeKalb cases and the Fulton Waffle House robbery. Lots of things that are very similar. And so perhaps it would have been easier if I had filed the severance already and we were addressing it that way. Not that Mr. Opinion is responsible for this indictment, but I think the state muddied the waters itself on this one by joining two separate and distinct incidents. Perhaps just for the impact of, he's a bad guy. He commits robberies and he commits murders, which I think is certainly part of the package we get before a jury, and even just looking at the indictment and realizing, oh, it's really two incidents. It's not just a armed robbery where someone happened to be killed. He robbed somebody the day before, killed somebody the next day. A lot of people may just, for lack of a better term, tune out at that point. And so again, yeah, I'm saying necessity, but the court correctly framed it within the frame of 403. It's just not probative. It's not meaningfully probative of anything because the state has the evidence that it needs for that. And certainly the robbery, as you indicated, the DeKalb robberies have no help towards anything involving the shooting of Mr. Murray.
But so you said you're going to jump to the end and you'd say, look, let's just ask witnesses about the cases. If you have Ms. Blanton on the stand and you're conducting the direct examination and you want to get in the fact that Ms. Blanton has said or may say again, if she's consistent, casino, or wherever she's going to refer to, whoever she says the person was, said he did these things. I guess she just need to be counseled a lot in advance to not refer to other things, or I just don't know how clean that is. That's the part I'm talking about where I don't know that surgically you can remove that. It's tricky with lay witnesses who are asked narrative questions.
Yeah, but I think, so the question is okay, so I'll approach it, I'm talking about as I go along at this point.
Sure.
I'm approaching it as if theoretically we have a severance and we're trying to figure out how is she able to talk about, give a forthcoming narrative, understand that she may be impeached or refreshed upon her other statements. As it pertains to the murder charge, again, I don't think the question is going to be, you were in the car with the guy, right? He told you some things about a murder. What did he tell you about the murder?
Yeah. And you would hopefully give the prosecutor some leeway in structuring questions so that they're cabin.
Yeah, I think.
Did he say anything about a murder? That's not leading technically, but it could cause a defense attorney to perk up, but that's a safe question to ask as opposed to what did he talk about?
Yeah, especially in light of the fact that we're trying to prevent the bigger harm of this unnecessary prejudice for something that's not related to this particular incident. And so I think, in as much as the Waffle House robbery and closing, there's not a lot of new property value that's needed from the DeKalb allegations, and there's no relation to it whatsoever to the murder. I think the DeKalb allegations only serve to confuse the issue, and doesn't add anything that is not already established by evidence that Philly's gonna come in, which is there's mass, the DNA, the mass was worn at this robbery in Fulton County. There's not a need for any discussion of the DeKalb stuff, so it doesn't need to be parsed. And in terms of asking, well, what did he tell you in the car? Just by kind of funneling in and tunneling in and saying, we're talking about this murder allegation. Were you told anything about a security guard at a recording studio? What were you told? Again, I think it's a fairly straightforward.
Then she could talk all about, he had this rifle and there was blood on it, and that's not getting Waffle House into the mix.
Correct. Because the rifle is particularly about the gun that was taken after the gun was shot and killed.
Okay, what else?
To be honest, Sean, I think that is the sum of my argument. I'm going to use the term necessity again, just because it's easy to frame it that way. But
I know what you mean.
yeah, the necessity for the DeKalb allegations as pertains to the Fulton Waffle House, the evidence is not needed to prove it. It's a case that stands well on its own, and the DeKalb robberies are not at all related or probative at all in the murder allegations. So for the fact that we have what we need to have a fair trial in Fulton County based on what we know about the Fulton County stuff, Ms. Blank's testimony was largely probably centered more so around how she knows Mr. Goolsby, more so than the substance of what she said. The motivations of why she said it will perhaps come up, but that's not going to be figured out by the fact that there's a fact about he got some money from a burglary, from a robbery in DeKalb County. None of the questions that I imagine she would be asking direct or cross-examination will give or deny her the ability to have credibility because we don't talk about it. So,
Okay, thank you. So, Mr. Pinion, as the movement, I'll let you go last. Tell me what your thoughts are about the discussion that Mr. Franklin and I just had about how Ms. Blanton's testimony could be, how the questioning could be structured so that you wouldn't necessarily need to cross the lines. This is assuming that the charges are severed. So if there is a Lydell, there's a murder trial, and then there is a Waffle House trial, two separate trials. And I focused on the murder piece. Why would it be so difficult to navigate what you're saying is this inextricably intertwined? I couldn't meaningfully question her because she's going to start talking about Waffle House. And I appreciate how it is sometimes difficult to ensure that a lay witness doesn't blurt something out. That's not my point, because we could caution her. I could caution her outside the presence of the jury. Don't ever say Waffle House unless someone asks you specifically about Waffle House. So assuming that she could be managed in that way, how do you think it would unfairly hamstring you if Waffle House wasn't coming in? Because one of the main arguments you made is that I can't have meaningful, credible testimony from Ms. Blanton. She's going to get attacked, as she should be if Mr. Franklin's doing his job. And I need to be able to rehabilitate her, make her seem credible, et cetera. And that's going to be real hard if we can't talk about Waffle House.
Okay, Your Honor,
Does that make sense?
Yes, yes, I think you're correct, yes, that, her credibility will be attacked, and, one of the things that makes her credible, where she's talking about she sees this assault rifle that has blood on it, and by the time the police find the car weeks later, a clip and a scope are in there, but that rifle's missing, so her credibility is going to come to issue, not only as to her ID of who the defendant is, but then what we see is, okay, she's saying this, but is the jurors want to know where she consistent, you start looking, are they consistent across a longer period of time than that? Well, she's also saying he said he was making money like $2,000 per Waffle House robbery, and he's doing it with this clown mask. Well, then if we, then lo and behold, there's a clown mask in the car. And so if the jury heard that, but didn't hear, they just heard he also has a clown mask. Well, he's driving that car and there's a clown mask. So, but it's significant that you can see somebody in the stills that appears to be the defendant's build, height, and the defendant's statement to police was he was so high on drugs he couldn't remember what happened during this time period. But when we listen to his jail calls, he's saying he loaned the car out to somebody, but he's not going to say who. So we expect that he's going to try to, the mysterious son of the dude that borrowed the car. And so if he borrowed that car, if he let someone borrow it, then why is the mask that's in that vehicle that has his DNA on it shown on videotape for 3 different times? So that's probably my strongest argument. It really goes against what I see him at least professing on jail calls, what his defense is gonna be. That some other dude had his vehicle at that time. So I don't know many other defenses he could come up with other than that. And given that, it's going to be extremely important. I will say also, there is a jail call, where he's talking to someone, and I told defense counsel about this one before the hearing, that he's telling the person that, and I'm going to quote it verbatim, they got the goddamn shit out of the car. And the person says, what are you talking about? He says, the goddamn, the goddamn clip and the mask. So, and he's putting them together again. The clips from the
Lydell incident.
Yes, Lydell. They're not the ones used to shoot him in the head. They're consistent with what was taken. And then the mask is not, as far as we can tell, I don't think he walked up the street guard with a mask on. You can't tell grainy, you can see some sweatpants without a stripe. But I think the security guard would have acted differently. But that's consistent with him walking into the Waffle Houses too without the mask. He would come out of the bathroom with it. So that's it. The case I cited, I think it's page 12.
You cited cases that support the proposition that inextricably intertwined or crime spree evidence comes in independent of a 404B analysis.
Yes.
There's always a 403 analysis, and I'll need to weigh that. I hadn't thought about it the way Mr. Franklin did about, as he called it, the necessity. That to me goes to the Waffle House piece of your case. I'm working through the murder side of your case, and I guess what I'm taking from what you're sharing with me is that one way to rehabilitate Ms. Blanton, assuming her credibility is attacked and she's impeached, and it sounds like all of that will happen in multiple ways, would be to show how other things she told the police about who she thought the suspect was are corroboratable.
Correct.
He talked about robbing Waffle Houses with a mask, and lo and behold, Waffle House mask is DNA. So that goes to assuming, I don't know when she told law enforcement that there's not some other way she could know that. It may be, I don't watch the local news, that everyone could have said, there's a guy who wears a silver clown mask who robs Waffle Houses right now, because it was all on the news. And then that's less, the only way she could know it is because the perpetrator told her, kind of thing. The thing about the gun and the blood and the clips, that sounds like it would come from the mouth of the perpetrator or someone close to him. But that's murder only. That's not something that would be excluded if I denied the 404B piece. I don't know, a lot of this hinges on whether there's a severance or not. So I may well enter an order that says, here's how I rule if we're trying everything together, and here's how I rule if things are being tried separately. And I don't know if I grant the severance, but I can rule. It's not going to prevent me from ruling on the 404B. And as with the other orders, I'm happy to revisit it if something changes. It could be that we're in a different posture. There's not severance, but Mr. Goolsby pleads to the armed robbery, and certainly not something that's going to trial.
Yes, and I think you are aware that this conversation about the Waffle House and the murder were all at the same time in the same place in this Grand Prix.
Yes.
So yeah, it's just, that's why it's not like they're together talking about it on multiple.
No, I didn't think there was a murder conversation, and then the next time they were together, an armed robbery conversation. But it does seem like if you wanted to explore what Ms. Blanton thought she knew about the defendant's involvement in the murder, say, well, did he ever, while you were riding with him, after she's identified him and talked about the Grand Prix, did he talk to you at all about killing someone? How do you word it? Yeah, and then she can go to town about the pistol and the long gun and blood and this and that. You can get into clips that were recovered from, you get into clown mask that was recovered. The jurors may wonder why you're talking about that if it's murder only.
Yes.
I just, Ms. Blanton shouldn't be unfairly hobbled from a credibility perspective because Waffle House is not coming in. But I don't know that the only reason Waffle House should come in is because it enhances her credibility. That's sort of what I'm wrestling with. I appreciate your concern that she is going to walk into the courtroom with credibility issues. If in fact people were saying, we can help you with your charges, or she was leading most conversations with, hey, if you'll help me with my charges, I may have something interesting. Jurors are going to weigh that how they weigh that.
And I did forget one thing. During this, he was saying he also had a gold chain that he said he'd gotten, and that was actually from the Fulton County armed robbery of the Waffle House.
Okay.
So he's showing things he got from both at the same time. I didn't mention that.
And you believe the gold chain is from the Fulton County Waffle House because it was recovered and returned?
No.
Or?
She said that he was showing a chain he got, and
I may interrupt Mr. Payne. So she's not showing things from the cab robberies, right? She's showing she's saying he's showing the gun from the Fulton murder and the chain from the Fulton murder. He's not showing money or proceeds from robberies in Waffle House and Fulton or the cab.
well, there wasn't breaking it down like that, but he was showing a chain he had gotten, and the only chain that we know is stolen is the Fulton County Northside Drive. John Adams, the person that was shot, he had a gold chain stolen.
Okay. But she, Ms. Blanton, doesn't say that whoever was talking to her said this gold chain was from the Fulton Waffle House. He's just saying, here's some of my loot. I do these things. I hit Waffle Houses. I shot this security guard who thought he was all that and a bag of chips. And so he got what was coming. So I got his guns. I got this gold chain. Okay.
It's not broken down.
Okay. All right. Thank you. Okay, well, I need to work through that as well. Are we good with discovery? Other than, I mean, jail calls might keep trickling in.
It's all been served. I did, as I'm working through all these calls and such, I did let Mr. Payne know there were a couple files that was like, I cannot access it. It popped up with a little red X corrupt.
Okay.
So we'll talk about it, and it'll probably just be easy for him to recopy everything on a flash drive.
But those files weren't your client's statement to law enforcement or something of that magnitude.
So I've not been able to find the click. So I have the mention in the discovery that just says, he said he was talking. The actual file that plays that, it may be in a folder that I can't get to.
Okay,
So, but he served it, it's just that as I'm
Okay.
trying to click through everything, I'm realizing that certain things just aren't opening and it may be computers I'm using or it may be the actual files.
the file type or who knows. Okay, well, we can work through that. But it looks like you were given everything, you just may not have had access to everything.
Correct. I've had cases where I complained, oh, I wasn't given this and this, but this is a case where everything was served a while ago. And aside from GPR reports that I think came in like in June or whatever, that Mr. Penny put into the motion.
Yeah.
I'm not consciously aware of anything that I'm lacking.
Got it. Okay, well, Mr. Goolsby, I need to rule on both these motions, the identification motion and the 404B. After I've done that, I think this case is ready for trial. I know you are ready for trial in the sense that you've been sitting in jail for a long time. Whether you ultimately go to trial or not is certainly a decision for you and Mr. Franklin to make, but I've explained to him that your case is one of the older ones and it will be towards the top of the list when we can do trials again. I don't know exactly when that will be. We're hoping to do some real trials. We call them test trials. There'll be real trials of smaller, simpler cases early in the year. And if that works and it's safe, then we may start moving some of the cases here. Mr. Pinion, anything else in Mr. Goolsby's case?
No, Your Honor.
Mr. Franklin?
Nothing for the court. I would ask for a few minutes after court to keep Mr. Goolsby in the courtroom. I'm going to play at least one phone call for him.
Okay. 4:20, can they have a few minutes to play a phone call before you guys take them?
The transport unit is waiting, they keep calling me, asking how long.
How long is the call?
5 to 8 minutes, pardon me.
If you keep it under 10, I'll take the hit from transport. All right, so Mr. Pinion, if you'll scoop, you can play the call.
And I know Mr. Shepherd was wishing to talk to us.
We're resetting, there'll be some, Ms. Nelson will set a teleconference so we can talk about scheduling. But I think I'm gonna wanna wait till Mr. Hudson is able to join us.
And go through.
Yes, sorry.
Mr. Shepherd wouldn't be upset. Mike Sprinkle, I told him I would tell you this, from our office, did the searches for Instagram. He actually was hospitalized this week with kidney stones.
Ouch.
So I just talked to him before I came in and he sounded drugged.
Yeah, no, I heard, so Mr. Shepherd knows that, and Ms. Nelson mentioned that about, that Mr. Sprinkle had been hospitalized, and so we